The petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount with certain conditions.
NDPS.
For reasons mentioned in the order, the interlocutory application is dismissed. And the criminal petition is filed for hearing after 2 weeks.
Lordship may fix the date. In the meantime, I will develop all this.
After 2 weeks.
May it please your lordship. Lordship, I beg to mention for listing a bail application for motion for Thursday, lordship.
Before senior court.
Like,
May I please, your lordship? With consent of other side, I beg to mention item number 19, my lord. In this case, I have to file objection, my lord.
You are seeking an adjournment.
Lordship.
Heard Mr. H.A. Ahmed, learned counsel for respondent number 2, who prays for an adjournment. On what ground?
I have to file objection, my lord, in this case.
Praying for some time to file a written objection against the criminal petition filed by the revision petition filed by the petitioner. He submits that he has informed the counsel for the petitioner regarding his prayer for adjournment. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
May I please?
Hello.
I beg to mention item number 5, my lord. I am for the petitioner. My lord, I would like to file an additional affidavit to furnish the document.
Heard Mr. K. Bhuya. Today itself or you want time?
On a template.
Heard Mr. K. Bhuya, who learned counsel for the petitioner, who prays for some time for filing an additional affidavit by the petitioner in this case. The prayer is allowed. Let this matter be listed after a week.
Hello.
May it please, your lordship. I beg to mention item number 38. Lordship, I pray for an upgradation at 2, lordship.
No upgradation.
Lordship, then before rising your lordship, because last occasion matter.
Wait for your.
What happened, lordship? We challenged a criminal proceeding on the 2 premises, lordship. One,
No hearing now. Wait for your turn.
lordship, before lordship's rising matter may kindly be taken up. We'll wait for.
You are wasting time of the court.
maybe listen. I beg to mention item number 3, madam.
Yes.
Adjourned for the day.
Heard. What is your name?
A. Mundal.
Heard Mr. A. Mandal, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Objection.
May I please, your lordship? Lordship, item number 31.
31.
Adjourned for the day, lordship.
Heard Miss. What is your name?
N.A. Begum.
N.A. Begum, learned counsel for the petitioner, who prays for an adjournment. The prayer is allowed. Let this matter be listed. Prayer is allowed. Stop.
Just listed after Bihu holiday. lordship.
No, the registry will list it accordingly. Yes, next.
Wait, please, your lordship. Lordship, I beg to mention item number 13, lordship. Can it be taken up at 2, lordship?
No. Item number?
1, 3, lordship. 13.
No, we'll go serially.
I have a case at court number 3, lordship. That's why I'm fixing for at 2, lordship. It's call I do to item number 15 in court number 3, lordship.
Okay.
Other.
Okay.
I live. 13, 1, 3. At 2.
Motion item 4.
May I please?
My lord, this criminal revision petition is filed against the import order dated 13 to 25 at page 15, my lord. This, my lord, the mere petition that has been rejected without any specific, my lord, ground. May I read, my lord? Page 15.
This is a interlocutory order. Revision does not lie. Whether revision lies against an interlocutory.
That's why the revision has been filed, because the order has been passed by the special judge. That's why.
No, revision does not lie against an interlocutory application.
Revision cannot be lie against interlocutory.
Whether a revision is maintainable under against this is an interlocutory application. Interlocutory order.
My lord, pardon, my lord.
The order which is impugned here
Yes.
is an interlocutory order.
My lord.
And therefore, my query is whether the revision is maintainable. Is there a statutory bar? Is there 438?
I think, my lord,
Your thinking will not help.
earlier cases in a similar line, that has been order has been passed.
Okay. So we can also pass orders. You read 438. Clause 2.
My lord. Close to the power of revision confirmed by the not in lesson 20.
Heard, Mr.
Now, I may be allowed to file, my lord, to withdraw and we file the appropriate order.
Heard, Mr. A.H. Laskar, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant revision petition with leave to file an appropriate application before the appropriate forum. The prayer is allowed. This revision petition is dismissed on withdrawal with the leave sought for granted.
My lord. My lord.
May I please the lawsuit kindly pass it over kindly.
So,
May I please the lordship?
yes,
So this is a application under 28 of the ENSS. Concerning an order, whether 15 page Malok. Lordship may kindly come to annexure 1, page 13 Malok. These cases arisen out of a domestic violence case Malok. Page number 13 Malok.
which is the impugned order? Page 1-3.
Impugned order is at page annexure 4,
Page,
page 65 Malok. Before that, may I bring your attention to your lordship at page 13 Malok.
just a minute. Yes,
Malok. Page number 13 Malok.
yes.
Here, this is a DB application under section 12 of the Domestic Violence Act. Now, here the aggrieved person is number 1 and number 2. Number 1 and number 2 have jointly filed this DB application against respondent number 1 is the son of aggrieved number 1, and respondent number 2 is the daughter-in-law of respondent number of the 80% 1. And my lord, respondent number 3 and 4, they are the elder brother and younger brother of respondent number 2, who do not have any sharehold in the property matter. So, my lord, to attract this under the DB Act, they cannot be bring to the DB Act, my lord.
Why?
Because, my lord, if your lordship see, my lord, there is the DB Act, who is the aggrieved person.
Yes.
Definition, madam. Section 2(1). Here it says now, at, madam, 2F, domestic relation means a relationship between two persons who live or have at any point of time live together in a shared household
So,
when they are related to the conjugality, marriage, or through a relationship in the nature of marriage, adoption, or are family members living together as a joint family.
and your case is
My
that
case is, my lord, that if you look again come to page number 13, annexure 1, respondent numbers 3 and 4 are the elder brother and younger brother of respondent number 3. They do not share any house, my lord.
3 and 4 are the elder and brothers of respondent number 2.
My lord. Yes, my lord.
Who is respondent number 2?
2 is the daughter-in-law of agreed person number 1.
Daughter-in-law of?
Agreed person number 1. Romola Das.
Okay.
So, my lord,
And one is the son.
one is the son, my lord. One is the son. And agreed person number 2, she is the sister of respondent number 1. He is residing at West Bengal. Now, madam, in this case, madam, I am not on that, madam. I am on respondent number 3 and 4. Whether they can be booked under the DBA.
Why it was rejected? Where they stay now?
No, my lord,
They stay in the same compound.
no.
That is the address.
Yes, madam, they have intentionally shown that. My lordship will see, my lord, respondent number 3, his address has been shown through Bonita Medi, that is respondent number 2. And respondent number 4, he researches Baksha.
Why your prayer was rejected?
Yes, madam. My prayer, madam, we filed an application that is at annexure 3, madam, for striking off the names of respondent number 3 and 4. But, however, that was not allowed and rejected.
What was the reasons?
Reason is that it's previous year, madam. Lordship will get this at page number 66. Last paragraph, madam. Page number 66 of the impugn order. Last paragraph. What are the points raised?
What is the wrong in the order?
Wrong in the order, my lord. If this is allowed, my lord, that means, my lord, after conclusion of the trial, they will be unnecessarily pulling the court, my lord. Both of them are working. One is working at.
So your submission is that domestic relationship has to be determined
yes,
at
ma'am.
the initial stage.
Yes, my lord. And my lord, that in my lord, sections 2S, this is also, my lord, very specific, my lord, that share household. What does share household means, my lord? Section 2S means a household where the person agreed live or at any stage live in a domestic relationship, either single.
But whether the aggrieved persons have made any statement in the complaint that they reside in the same shared
No, my
house?
lord, no. That also not made.
No such.
No
state.
such thing, my lord. Possibly, my lord.
And where does
The
petitioner number 3, respondent number 3 stays?
respondent number 3, and he is working at Guwahati, my lord.
Where he stays?
My lord, he stays in, my lord, Godesguri area, my lord.
No, how this court will know that you are not staying in this shared house?
We cannot stay, my lord. How can we stay in others' house? My respondent number 2, she's the petitioner's sister, my lord.
No, the address is given this
My
same.
address is given through Bonita. We are not staying, my lord. But in my petition, my lord, in the post-title, my lord, I specifically mentioned my address.
heard Mr. S.P. Das, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioners, namely Pranjan Medhi and Surajit Medhi, impugning the order dated 15/2/2025 passed by learned Judicial Magistrate First Class Kamrup Metro Guwahati in DV case number 9/2024, whereby the prayer for striking out of the name of the present petitioners from the DV case number 9/2024 was rejected. Learned counsel for the petitioner.
Same,
What is this?
same, my lord. Here also, my lord, in the first case, my lord, here Lordship will find the daughter-in-law was full before the court. Ultimately, the court has
This is
struck off their name.
the learned counsel for the petitioners has submitted that the respondent number respondent number 1 and 2 have filed an application under section 12 of the Protection of Women from Domestic Violence Act 2005 before the Court of Learned Chief Judicial Magistrate Kamrup Metro at Guwahati as aggrieved persons against 4 numbers of respondents, including the present petitioners. Learned counsel for the petitioner submits that in the complaint filed by in the application filed by the respondent, the aggrieved persons, the petitioners are also shown as respondent on the ground that they are also stated to be in domestic relationship with the aggrieved persons. Stop. However, learned counsel for the petitioner submits that the respondent number 1 in the application, namely Pritam Das, is the son of the aggrieved person, as well as respondent number 2 is the daughter of the aggrieved person number 1.
Daughter-
In support of his submissions, learned counsel for the petitioner has cited a ruling of Bombay High Court in the case of Mrs. Jeba Mohsin Pathan versus State of Maharashtra, within bracket, writ petition number 5185/2008. Issue notice to the respondents. The petitioners shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 22nd of April 2025. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed here in above, further proceeding of DV case number 9/2024, for the present petitioners, namely Mr. Pranjal Medhi and Mr. Surajit Medhi, shall remain stayed till the next returnable date, list accordingly.
Obviously.
May I please, Your Lordship? This is an application under section 528 for quashing the impugned complaint dated 24/1/2024 in connection with CR case number 10/24, my lord. The gist of the case is that, my lord, we are threatening the witnesses and informant of session case number 103 of 22, which is pending before the learned additional session judge Kamrup Amingao, my lord. Instant complaint has been lodged before the additional CGM Kamrup, my lord. Later on disposed it before this, my lord, additional CGM for disposal, my lord. My lord, kindly have a look in page number 17, the complaint, my lord.
What is your ground?
My lord, kindly the learned court below take cognizance under section 195A of IPC, my lord. Kindly see section 195A IPC, my lord. Whoever threatens another with any injury to his person, reputation, or property, or to the person or reputation of anyone in whom that person is interested with intent to cause that person to give false evidence shall be punished with imprisonment of either description for a term which may extend to 7 years or with fine or with both. And if innocent person is convicted and sentenced in consequence of such false evidence with death or imprisonment for more than 7 years, the person who threatens shall be punished with the same punishment and sentenced in the same manner and to the same extent such innocent person is punished and sentenced. My lord, kindly see the classification of offense, my lord. Cognizable, non-bailable trial by the court by which offense of giving false evidence is triable. So, my lord, the trial case is going before the learned court of additional session judge. So that court should take cognizance, my lord. Otherwise, any other court cannot take the cognizance, my lord. The case in which we are giving threatening, my lord, to depose false evidence, my lord, that court can take cognizance, my lord. Otherwise, no other court can take cognizance, my lord. Here in this case, my lord, learned additional CGM take the cognizance, my lord, and issue notice upon us, my lord. In response, we appeared before the court will sought the bail, my lord. We are on bail, my lord, and the case is fixed for evidence before us. My lord, page number 25.
Why it cannot take cognizance?
My lord, so far as the classification,
Where,
my lord,
what classification of
my lord,
offense?
as per the classification of the offense,
That is
my lord.
not part of the statute.
My lord.
Whether a case is cognizable or not cognizable,
My lord,
you have to go to the schedule.
if we go through the classification of the offense, my lord, here in this, the court
Classification of the offense as per what provision?
but that is will go by the CRPC or BNSS, my lord.
Where is the provision? 340. Where is the provision? You tell me the provision that cognizance can be taken by.
My lord, earlier CRPC section 200 was, my lord, the earlier, as per earlier CRPC, my lord, taking cognizance, my lord. Now, my lord,
You come prepared. Mr.
my lord,
Come after full preparation.
my lord.
Mr. A. When heard Mr. A. Paramanik, learned counsel for the petitioner, who prays for listing this matter on Monday.
My-
So list this matter on 17/3/2025.
Highly pleased.
You show the provision.
My lord.
Good idea.
Also, it's an application for Jimba, 1.32 bore pistol bearing, and 9 rounds of live ammunition and 1 current checkbook, my lord. That's the
Where is the rejection order?
rejection order is at page number 35, my lord, and extra 6. He has the permission to purchase and carry the weapons, my lord. Annexure 7 is the
Why it was rejected?
rejected on my lord 17/12/24, my lord.
Why?
My lord, is stated that the IO stated that it's needs for investigation, my lord, but no specific reason is given, my lord. For it,
Okay, we'll
for-
call for the report. What was, how, why this was seized in connection with what case? Is it a wildlife case?
My lord,
Why your arms were seized?
but, an FIR was lodged, my lord, Annexure 15, my lord. But on that reason, my lord, my gun was seized, my lord. Annexure 15 is there.
You have threatened somebody.
It's an allegation, but my
That is an accusation. Okay. Then you may not get it. Heard, Mr. What is your name?
peace, my lord.
B. Saikya, learned counsel for the petitioner. Also, Mr. K. Das, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner impugning the order dated 17/12/2024 passed by learned Judicial Magistrate First Class Kamrup Metro Guwahati, whereby the prayer for Jimma of 1.32 bore pistol along with live ammunitions and one SBI checkbook, one leather sling bag was rejected by the said court. Stop. Let a report be called for from the investigating officer of Dispur PS case number 987/2024 as regards whether the seized articles are required for investigation or not, and whether same may be granted in Jimma to the owner of the said articles. The learned additional public prosecutor shall produce the report before this court after 2 weeks.
Yep.
On which date?
Lordship on
On 27th March.
Lordship.
27th March.
Much obliged.
May please, Your Lordship. This criminal petition has been filed by the petitioner stating the order dated passed by the learned Special Judge POCSO, Your Lordships, Kamrup Metro Guwahati, 2011-24. Annexure K page 52 is the impugned order, wherein the learned court below has charges framed against the accused number 1 and accused number 2 under the different sections of IPC and more particularly the section 10 of the POCSO Act. On the grounds of presumption, the very important thing is that the learned court below did not assign anything. What is the ground for taking the framing of charges? Based only on presumption, the learned court below has taken the section 10 of the POCSO Act.
Where is the order?
Page 52 of the petition, Your Honor, Annexure K. May I read the order, Your Honor? Page 52.
Yes.
Accused Connection Boro A1 and Suresh Suppa are present before the learned counsel. I've heard about sites on charge and gone through the case record carefully. Upon consideration of materials and record, the documents submitted therewith, and after hearing the submission of the learned counsel for the both sides, I am the opinion that there are some grounds of presuming that accused number 1 has committed an offense punishable under section 354 IPC as well as section 10 of POCSO Act, and also that A1 and A2 have jointly committed offense under sections 448, 323, 34 IPC. According to the charges in two separate states are framed against the accused person are same I read over and explain to them. When the contents of the charges read over and explain to the respective accused persons, they pleaded not guilty and claimed to stand trial. Issue some of the informant as well as victims so and so for 17 for evidence. Now this case has been coming in the floor of the learned court below based upon the FIR lordships, which is very much vital. Annexure B, page 19. Prior to that, there is a land dispute has been going on, civil dispute. Annexure 18, which is it's an agreement between the informant and the accused person, one of the accused person. The accused number 2. Page 18 is a this is a sale agreement for purchasing and a land, and for which some amount has been given by the accused number 2.
What is the error in the order?
Error, yes, lordships, kindly if you go to the FIR, lordship, there is no such ingredients has been attracted to say that section 10 of the POSCO Act will be attracted. More so, when the section 9 of POSCO Act is, if you go to the grounds, there's no such materials, so intentions has not been there, your lordship. For attracting section 10 of POSCO Act, certain conditions might be fulfilled. That is, being a police officer, neither he is a police officer. Now, not an armed member of the armed forces, nor being a public servant, nor management of any staff, for management or any educational staff.
No, these are necessary for section 10.
10. In this, if you go to the root of the case, your Honor, he is neither a armed forces persons, not a.
But this is not required for framing charge under section 10. Section 10 is only aggravated sex.
Yes, for that purpose, your lordship, section 9 is important for definitions.
What is the age of the victim?
12 days.
So that is enough.
That is enough, but the thing is that section 9, if you go attracted section 10, section 9, the definitions for which a sexual assault has to be fulfilled. He must be a police officer.
No, you are wrong. Aggravated sexual assault may be for various reasons.
But the reasons has not been assigned. More so, your Honor, the case is a civil dispute, and the intention has not been come up from the very facts of the case of the matter. If you kindly go to the Annexure B, page 19, the
Now
FIR.
you tell me the grounds on which
No.
this court should exercise powers under inherent power.
The
First submission you made that the trial court on the basis of presumption framed the
charges.
What is required? What is the criteria for framing charges?
Now the required is section 9, the very much, your Honor. Section 9, if you go attract section 10, section 9 says he must be a police officer. Second,
Unless he is a police officer, section 10 charges cannot be framed. Is that your understanding?
criteria is there.
No, is that your understanding of law?
If the Honorable Learned Court below has framed charges on different section, there is something we can say. But section 10, materials, what are the materials she has been taken into account before framing charge? That is one of the most vital factor of the entire matter. The FIR itself says there is no intention whatsoever. Only the girl has been dragging out from the house. Whether from dragging out from a house or pulling her from a house, it is a conflict, there is a conflict. So whether the section 10 would be attracted or not, that is a moot question of the entire matter. There is a conflict between the parties. And for that reason, a girl has been dragged out. Not only the victim girl, informant has also been brutally he has also been manhandled. And the medical report itself says there is no such incident will happen. Can you see the medical report, Your Honor?
No, we will not go into medical report at the time of framing of charges.
But
You pinpoint your argument. Why the order framing charges is wrong? Why?
because number one, the only based on presumption. Number two,
What should be the criteria?
because section 9 itself says
No,
that
what should be the criteria for framing charges?
the evaluation, all the materials has to be taken account before framing the charges.
Okay,
This is the apex for various judgment has been taken out before framing the charges. You have to look at entire aspect of the matter. Now, section 9 has says there are the ingredients for which section 10 would be attracted. None of the section 9 has been.
Section 9, clause M, read clause M.
Moreover, section 29 is also there. Presumption is there. Section 29 of POCSO Act.
You
No,
you don't have a case.
No, Your Lordship,
We are not, we are dismissing it.
No, if Your Lordship, may I pray before the Lordship to call for a record of the case, at least.
No, we are dismissing your petition. You don't have a case. Unless you satisfy that, why have you challenged?
Your Lordship, another date may be fixed, Your Lordship. I will place some judgments also for that reasons.
Heard Mr. H. Burwa, learned counsel for the petitioner, who prays for listing this matter, who prays for some time so that he can bring some authority to substantiate his submission that he has a case for invoking inherent jurisdiction of this court under section 528 of BNSS. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
On Monday, if Lordship, Monday,
No,
if it's possible.
in the next week on a date to be fixed by registry.
Neatly, Your Honor. Also, here the petitioner is filing this petition for recalling the warrant and PNA issued against the petitioner.
Why you defaulted?
Also, I was granted bail on 9/11. Okay, granted bail on 1/6/2020. During the period of COVID.
You were granted bail in this case.
Yes.
Where, now,
Page
the
number
case is
28.
pending before Sessions Court.
Yes, Lord. Page number 28, Lordship.
Thereafter, what happened? After
Thereafter,
taking bail, you,
Since he is granted bail due to decongestion in jail, Lordship, decongest the jail, Lordship. Lordship, he lost the communication because of he could not have any communication with his advocate. And moreover, Lordship,
when the order, when the non-bailable warrant was issued,
non-bailable warrant was issued on page 29, Lordship, 9/11/2021.
21,
Yes, sir.
Into bailable.
No,
and
bailable.
No,
Lordship,
30 non-bailable.
30 non, page 30.
17/12.
page,
Page 30.
Lordship. 17/12/2021.
then what is the status? How many accused persons are there?
Single accused.
Only you are there. And what is the next date fixed?
Next day, 3 is today, Lordship.
You appear today.
I cannot appear today, Lordship.
Uh-huh.
At least 10 days time may be given, Lordship.
Why? You,
Lordship, he was issued, before that, he was issued non-bailable warrant, page 29.
heard Mr.
Yes, yes.
S.J. Sharma, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Mahendra Gogoi alias Rajiv, who is aggrieved with the order dated 17/12/2021 and subsequent orders passed by the Court of Learned Session Judge Court of Learned Additional Session Judge within bracket FTC Lakhimpur, North Lakhimpur in Sessions case number 31 within bracket NL slash 2019, 2019, whereby non-bailable warrant of arrest were issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner is facing a trial under section 376 slash under section 448 slash 376 slash 379 of the Indian Penal Code before the Court of Learned Session Judge, before the Court of Learned Additional Session Judge FTC Lakhimpur in Sessions case number 31 within bracket NL slash 2019. He submits that he was also granted bail by the said court on 1/6/2020. However, as the bail was granted when the COVID-19 was prevalent, was still there, he lost contact with his engaged counsel and was unaware about the dates fixed before the trial court. Learned counsel for the petitioner has submitted that the petitioner is ready to appear before the trial court and face the trial. However, some protection is sought for as non-bailable warrant of arrest has been issued against him by the trial court. Stop. Considering the submissions made by the learned counsel for the petitioner and also considering the facts of this case, which shows that the petitioner was once granted bail by the trial court, this criminal petition is disposed of with a direction to the petitioner to appear before the Court of Learned.
Additional session judge.
It is before Session Judge, I think.
Session judge Lakhimpur.
Court of Learned Session Judge, Lakhimpur, North Lakhimpur, within a period of 10 days from the date of this order and cooperate in the trial to facilitate his appearance before the trial court within the aforesaid time. The operation of non-bailable warrant of arrest issued against him by the trial court shall remain suspended for next 10 days. With above observation, this criminal petition is disposed of.
May I say that, Lordship? Lordship, 482. Lordship. FIR on page 16, Lordship.
Yes,
May I read, Lordship?
yes.
With reference of the to the subject cited above.
Is it regarding same case
Yes,
where
Lordship.
yesterday you
Yes,
got
Lordship.
in-
Item number 17.
you have orders which was passed yesterday?
Lordship.
You have the copy of the order which
We are not online, Lordship. We apply for a certified copy.
when the case diary is called for?
28.
Same case,
Same.
28,
28.
same order. You appear before the trial IO within 10 days, same order. কিন্তু
28.
কি নাম তেওঁৰ? হিমন্ত মুনমুনৰ পৰা আপুনি ড্ৰাফটটো লৈ ল'ব। Same order.
Organizers.
Your- The order will be same as yesterday.
All right.
May I please, Your Lordship? My Lordship, my limited prayer, my Lordship, is that non-bailable warrant, page 34, has been issued. Date is on 19/3/2025, my Lordship. I live here. Inadvertently, my Lordship, there was a talk going on for outside settlement.
The
as well.
case is pending,
No, my Lordship.
It
The
is
case has been disposed of.
disposed of.
NI case, my Lordship. As because some negotiations were going on.
You are convicted
Yes, my Lordship.
and you have not preferred any appeal.
No, my Lordship, because there is a negotiations going on for settlement of the issue with the.
So what is your prayer?
My prayer is that, my Lordship, I'll appear before the court and necessary application I'll file, my Lordship.
When?
On 19/3/2025 is the date. my Lordship.
Heard Mr. S.B. Laskar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, Shri Dipankar Deka, who is impugning the order dated 27/1/2025 passed by learned additional chief judicial magistrate Morigaon in CR case number 711/2021, whereby non-bailable warrant of arrest has been issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner has been convicted by the trial court in CR case number 711/2021, and he was convicted 7/11/2021 under section 138 of Negotiable Instrument Act 1881, and he was sentenced to undergo simple imprisonment for 3 months and to pay a fine of rupees 6 lakhs. Learned counsel for the petitioner has submitted that the petitioner has not preferred any appeal against the order of conviction, as a talk of compromise is going on between the petitioner and the respondent number 2. Learned counsel for the petitioner has submitted that the next date of the CR case number 711/2021 is fixed on which 19/3/2025, and he is ready to appear before the trial court on the said date. However, he seeks some interim protection as non-bailable warrant of arrest has been issued against him. Stop. In view of the submissions made by learned counsel for the petitioner, as well as in view of the facts and circumstances of this case, this criminal petition is disposed of with a direction to the petitioner to appear before the trial court that is the Court of Learned Additional Chief Judicial Magistrate Morigaon in CR case number 711/2021 on the next date fixed, that is 19/3/2025. Stop. In order to facilitate his appearance before the said court, the operation of non-bailable warrant of arrest issued against him by the said court shall remain suspended till that date, that is 19/3/2025. With above observation, this criminal petition is disposed of.
Highly obliged, my Lordship.
In this case, your lordship has already had the matter. Only the LCB was supposed to place on record, my lord, as to how they are saying that I am also engaged in another narcotics case, my lord. Because that's why your lordship sought for a report on that basis.
I have forgotten everything.
Oh, yes, then my lord, I will come.
You
Lordship, allow us 2 days time, Lordship.
2 days time to what?
Chief, we could not communicate with the department, Lordship.
That's their fault, my lord. They got 10 days time, my lord, from the last day.
2 days may be granted, I think.
My lord, I'll not say anything, but thing is that they
There
were,
are, your prayer is on the ground of prolonged incarceration.
yes,
And
and nothing
you're,
was recovered from my
you are
possession.
following the car,
Yes, absolutely.
following the vehicle,
Truck,
in which,
yes. That's
But-
why I was never,
okay, let them take 2 days time.
my lord.
Heard Mr. Z. Kamar, learned senior counsel assisted by Mr. P. Dev Chaudhary, learned counsel for the petitioner. Also heard Miss, what is your name?
And Kakoti, Lordship.
N. Kakoti, appearing for NCB, who prays for 2 days time to,
13 March, Lordship.
who prays for some time to place on record the incriminating materials against the present petitioner and also make submissions on behalf of NCB. The prayer is allowed. Let this matter be listed again on
13, my lord.
13th of March.
Bless, Lordship.
Next 13 of the month. Next medium, one of the line. Yes, Mr. Ahmed,
Yeah, please, Your Lordship.
what is this?
Lordship, here the petitioner was arrested, Lordship, on 1/12.
FSL report is there.
Lordship, FSL report we have received, Lordship. Yeah, but the FSL report it is cannabis, Lordship.
Cannabis.
And recovery is 2 kg, 2276 gram. So it's commercial quantity.
2
76.
What is the commercial quantity of cannabis?
Can I give a 1 kg?
What is the difference between ganja and cannabis?
My lord, the plant is, Lordship, cannabis. And Lordship, if it is the flowering top and the fruiting tops, Lordship, if it is separated from the plant, Lordship, perhaps, Lordship, that would be ganja, Lordship. And Lordship, the other part, Lordship,
Plant is also a prohibited.
yes, Lordship. But here, Lordship, my argument would be, Lordship, this is, Lordship, may kindly come to the FIR first, Lordship. This
Just
is relating to, Lordship, cultivation of cannabis, Lordship. And my submission would be revolves around basically, Lordship, if it is cultivation, Lordship, then the conception of commercial quantity, small quantity or intermediate quantity will not come.
In the notification, where is the cannabis?
Serial number 23, Lordship. perhaps.
23.
23, Lordship.
It is
Definition is 2, section 2.
23.
Section 2. Roman 3.
It is charas or hashish.
Charas and hashish, Lordship, if, Lordship, we collect some liquid from the plant, Lordship,
Yes.
kindly come to the definition part. Lordship.
Section 2.
Section,
1 to 12, section 2, 3, Roman 3. Roman 4.
section 2, Roman 3, Lordship.
Roman 3 and Roman 4.
Cannabis hemp means charas, that is the separated resin. Means, Lordship,
So
the
under
liquid.
23, it has to be
Ah.
charas or hashish.
Yes, Lordship.
That-
And Lordship, and Lordship, if it is related to cultivation of cannabis, Lordship, then my humble submission is, Lordship, the
No,
conception of,
what are the facts of this case?
Lordship, may kindly come to the FIR. It is purely cultivation of cannabis. And Lordship, if it is cultivation of cannabis, the conception of commercial or small quantity will not be applicable. Page number 16, Lordship.
Yes,
May I read it, Lordship?
yes.
Sir, I am to inform you that on so and so at so and so, the additional so and so had thus arrived at the OP and conveyed secret information to the IC so and so about cultivation of cannabis on a large plot of land at village Kanaimara Part 1 owned by Lalmia. Lalmia is the petitioner. This information was recorded by IC of so and so, so and so, so and so. The information suggested the likelihood of entry, search, seizure, and arrest, etc. before sunset. Accordingly, the IC informed all higher authority officers, and written authorization letter was issued to me by the additional SP headquarters so and so, so and so to search, seize, and arrest the informed location by so and so, so and so, and proceeded to the informed place. The following police personnel were also detailed by the IC to assist me, and the IC himself proceeded to the place of occurrence by so and so, so and so, so and so. I'm skipping the name of the witness, name of the party's lordship. I, along with the police party, used a departmental vehicle bearing registration number so and so, driven by so and so. We proceeded from the OP at so and so towards Place Kanaimara, equipped with an investigation kit, digital weight machine, so and so. Before reaching the spot, the following two persons, namely, I am skipping that lordship, the name of the witnesses. Now, lordship may kindly come to page number 17. We reached the informed place, that is the residence of Lalmia, at 3:30 p.m. at Kanaimara. Upon arrival, we cordoned off the premises and found the suspected person Lalmia at his own house. I identified myself before him and also offered him the opportunity to search me before starting the search. I inspected the nearby area in presence of the witnesses and located a large area under cultivation of suspected cannabis with plant about 7 to 8 feet high. The plot of land on which the suspected cannabis was cultivated was inside the compound of Lalmia. Information was given by the IC to so and so via telephone so and so about the existence of cannabis cultivation. At about 4 p.m., the additional SP, along with one executive magistrate, namely so and so, and 3 persons from Mankaso Revenue Circle arrived at so and so measuring equipments. Accordingly, so and so Latmondal, along with 2 helpers and assistance of police personnel, measured the area under cultivation in presence of witness, which was approximately 4 biga, 4 kattha, 5 lesa. He also ascertained with records brought by him that the land having patta number so and so belonged to Lalmia. The Latmondal measured the area where the cannabis plants were grown and found it to be 21 lesa. It had already apprehended that the landlord at the PO. I produced a notice under section so and so to the LS Lalmia to search the room and himself in presence of the aforementioned independent local witnesses while complying with the provisions of section so and so. As instructed by so and so, I directed 3 local persons. I'm skipping that also. Accordingly, they cut the cannabis plant. All the cannabis plants were assembled at one place. I collected 1.5 kg of cannabis plant randomly from the whole plants for sampling in presence of so and so. The same in presence of witness. The Latmondal also witnessed the same and signed the seizure list. The executive magistrate also put signature on the seizure list. Then I sealed the same in a carton with so and so.
Yes.
We also searched the house situated inside the compound of Lalmia and his family members and found some suspected processed cannabis in his house, or in the house of Bulu Rahman, son of Lalmia, in the northeast corner of the room. We opened the plastic polythene and weighed it using digital machine belonging to so and so in presence of the witness and net weight of 2,276 grams, 2 kilo. 276 grams. The above mentioned recovered items were seized by me as per the seizure memo in presence of the aforementioned 3 independent local.
Processed cannabis was 2,276 grams.
This is ganja, lordship.
No, this may not be ganja. This may be charas. This may be hashish.
No, lordship. Hashish, it should be liquid, lordship. Lordship, may kindly allow me to read further.
Yes.
The above mentioned recovered items were recovered as per the seizure memo in presence of so and so. The seized articles were packed and sealed by me with law in presence of so and so, and so and so. After completion of the whole proceeded in presence of the executive magistrate and so, the remaining assembled cannabis was destroyed by burning. It is to be noted that the whole procedure was videographed so and so. Lordship may kindly see, we opened the plastic polythene and weight is using digital machine belonging to so and so in presence of net weight is 2,276 grams. Lordship, that is dry cannabis, Lordship, that would be Lordship ganja. And it would be Lordship definitely be there in the seizure list, Lordship. Now, Lordship, so far as my submissions are concerned, Lordship, here the basic allegation revolves around cultivation of cannabis. Now, if it is cultivation of cannabis, Lordship may kindly come to section 20, Lordship.
Section
20.
yes.
Section 20 relates to punishment for contravention in relation to cannabis plant and cannabis.
Yes.
Whoever in contravention of any provision of this act or any rule or order made or condition of license granted thereunder cultivates any cannabis plant. Lordship, my case will fall under section 28. Cultivates any cannabis plant shall be punishable where
What is the punishment?
punishment, Lordship, 10 years. Number one, clause 1, Lordship, where such contravention relates to clause A, that is cultivation, with rigorous imprisonment for a term which may extend to 10 years, and shall also liable to fine which may extend to 1 lakh rupees. Now, so far as clause B, Lordship, manufacturers, possess, sales, etc., these are not applicable in my case. And Lordship, if it is Lordship, cultivation of cannabis plant, whether the conception of default bill will be applicable or not. My humble submission, Lordship, would be yes. And as because, Lordship, this is 10 years, I'm entitled for default bill once 60 days is completed. In this respect, Lordship, I'm relying on a judgment, Lordship, 2021 Criminal Law Journal 2513. May I please place a
The
copy?
punishment is 10 years,
10
which-
years,
which may extend to 10 years.
maximum 10.
But now BNSS, what it says, section, what is the provision? It is 10 years and above.
No, Lordship, my punishment is 10 years, Lordship. The maximum is 10 years. And if it is up to 10 years, Lordship, then it would be, Lordship, definitely 60 days, Lordship. And moreover, Lordship, in my case, Lordship, I'm in custody for more than 100 days, Lordship.
Okay.
It is judgment. It is judgment.
21.
What is this?
Lordship, this is a case, Lordship, of Madhya Pradesh High Court, Lordship, in which, Lordship, this issue, the similar issue was there, Lordship. The recovery, the case was revolved, the case basically was revolving around the issue of cultivation of cannabis plant and conception of default bill, and as well as whether commercial quantity or conception of commercial or small quantity is applicable or not, that has been decided. My lord, may I kindly come to paragraph number 22.
Para 22.
Para 22. Internal page 8.
Yes,
May I read it, Lordship?
yes,
Lordship, may kindly allow me to read from para 21, Lordship.
yes.
Now we see what will be the limitation for filing of challan in this case. The police filed the challan under section 8/20 of the Act. As per the prosecution case, 36 green, small and big plants of ganja were seized from the body of the accused. As per the allegation of the prosecution, the accused cultivated the aforesaid ganja plant. The investigation agency seized the aforesaid plants, and the weight of the aforesaid plants was found to be 1 quintal and 15 kg. As per the objection raised by the state, that the quantity is the commercial quantity. Therefore, as per section 8, read with section 20B2C of the Act, the punishment will be extended to 20 years with fine, and limitation period will be 90 days, while the challan was filed on 67 days. The aforesaid contention raised by the state is strongly opposed by the counsel for the applicant. It was submitted that the limitation period would be 60 days. The counsel has drawn attention towards section 36(4) of the Act. It would be useful to refer the relevant parts of section 2, 8, 20, and 36 of NDPS Act. Definition. The Act, unless the context otherwise requires, cannabis hemp means the definition part, Lordship. Charas, that is the separated resin. Resin means, Lordship, the liquid part, Lordship.
Yes.
In whatever form, whether crude or purified, obtained from the cannabis plant, and also includes concentrated preparation and resin also as hashish oil or liquid hashish. Ganja is that the flowering or fruiting tops of the cannabis plant, excluding the seeds and leaves when not accompanied by the tops, by whatever name they may be known or designated, and any mixer. Cannabis plant means any plant of the genesis of cannabis. Section 8, Lordship. Prohibition of certain operations. No person shall be cultivate any coca plant or so and so. Cultivate the opium or any cannabis plant. 8B. My case is, Lordship, cannabis plant. Punishment for contravention, that I have already read, Lordship.
Okay.
Now, Lordship, section 36A, the conception of 180 days that has been discussed. Lordship may kindly come to paragraph number 14. The 24th, sorry. Therefore, it appears from the aforesaid provision that section 8A of the Act is not applicable in this case, because the aforesaid provision is related to coca plant, etc. The present case is covered by section 8B of the Act, which prohibits the cultivation of opium, poppy, or any cannabis plant. Definition of cannabis plant has been given in section 2, Roman 3 and 4 of the Act. As per the aforesaid definition, the plant of ganja is also included in cannabis plant. Section 20A of the Act prescribes the punishment for cannabis plant, cultivation of any cannabis plant. As per section 20A(1) of the Act, the punishment provided for contravention related to clause A of section 20 is imprisonment for a term which may extend to 10 years, shall also be liable to fine of ₹1 lakh. It is clearly transferred from the challan that the matter does not cover by section 20B2C of the Act, because the matter is related to only to the cultivation of cannabis plant. The notification relating to commercial quantity does not cover the cultivation. Therefore, the offense under section 8B, read with section 20A(1) of the Act, is made out, for which the imprisonment may be up to 10 years. No minimum sentence is prescribed.
Okay. But what about the processed cannabis which was found in
My lord,
plastic?
that is ganja, Lordship. Lordship may kindly ascertain that from the FSL report, that part, Lordship. And Lordship, I don't have the seizure list, Lordship. We have applied for the seizure list, but that was not provided to us.
Okay. Under what provision the case was registered? 20B2C.
Yes, Lordship. 20A, capital B, capital C, everything is there, Lordship. And there 20 is there. And Lordship,
We are not sure, madam, which section it is to be on. Madam, one the point is, just let me, madam, add, madam, one the point is if it comes to AMI, supposing it is correct, assuming that it is correct, even then already he is entitled to get paid by. As per section 187 of the BNSS. Even if you do not go beyond that, madam, suppose admitting that, madam, even then, madam is entitled to get paid.
Yes.
Lordship. In Lordship, here in the FIR, Lordship, may kindly come to page 18, Lordship. Page 18, Lordship, FIR, Lordship. What
Yes.
the police has seized from the top lordship. Then I sealed the same in a cartoon with La taking the signature of the accused witnesses and myself. We also searched the house situated inside compound of Lal Mia and his family members and found some suspected processed cannabis in the house of Bulu Rahman, as a son of Lal Mia, in the northeast corner of the room. So, lordship, along with the cultivating cannabis, lordship, there was some process cannabis will also cease, and that is the quantity, lordship. I was at that time I was wrongly mentioned, lordship, that processed ganja is weight 2 to 6 gram is processed ganja.
Ganja, is it ganja?
That is processed ganja, lordship.
Is it ganja?
It is mentioned as processed ganja, lordship, but
If it is ganja, they will get bail.
lordship, it is processed ganja, but it was suspected. It was suspected, lordship.
What was found in FSL?
FSL, it is cannabis, lordship.
No, cannabis may be hashish, cannabis may be charas,
It is,
cannabis
it
may
is
be
cannabis
ganja,
only.
or everything different.
Confirmed as cannabis of the ganja, it is mentioned, lordship.
Cannabis oblique ganja,
Ganja, lordship.
then they,
Cannabis in packet ganja, it is mentioned, lordship.
then they will get bail. Heard, Mr. Is it ganja?
It is mentioned like that, lordship. I will not say anything more than
Heard,
FSL report, lordship.
Mr. H.R. Chaudhary, learned senior counsel assisted by Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. P.S. Lawkar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Lal Mia, who has been detained behind the bars since 1/12/2024 in connection with South Salmara PS case number 200/2024 under section 20 within bracket A small a within bracket small b within bracket capital B within bracket capital C of NDPS Act. The gist of accusation in this case is that on 30/11/2024, one Akashi Neog, SI of police, had lodged an FIR before the officer in charge of Harubanda Police Outpost under South Salmara Police Station, inter alia, alleging that a secret information was received through reliable sources regarding cultivation of huge quantity of cannabis on a plot of land which was owned by the present petitioner, namely Lal Mia. On receipt of the information, a police team proceeded to village Kanaimara, Part 1, and found large area under cultivation of suspected cannabis plant of about 7 to 8 feet in height. Stop. The police team collected the cannabis plant, cut the cannabis plant therefrom and collected the same, which weighed about 1.5 kg. Stop. Thereafter, the police team searched the house of the present petitioner, and during search operation, in a plastic polythene pack, some processed cannabis was found, on weighing, it was found that the weight of the same was 2276 grams of learned counsel for the petitioner has learned senior counsel for the petitioner has submitted that though this case has been registered under section 20 within bracket 20 within bracket small b within bracket 20b2c of the NDPS Act. However, it has been wrongly registered under said provision as the offense regarding cultivation of cannabis is punishable under section 20 20 within bracket small a read with 20 b small 1 small Roman 1 where the contravention where the punishment regarding cultivation of cannabis per plant is up to 10 years of imprisonment and also a fine up to which may extend to 1 lakhs of rupees. Learned counsel for the petitioner has further submitted that the processed cannabis which was recovered from the house of the petitioner, which weighed 2276 grams, is ganja, and therefore it is less than commercial quantity. He therefore, learned counsel for the petitioner therefore submits that in this case, the offense which is alleged to have been committed by the petitioner is under section 20 within bracket small a /20 within bracket small b clause small 1 and 20 within bracket small b clause small 2 clause capital B of the NDPS Act, for which the maximum period of detention is 60 days only. And the petitioner has already undergone the detention for more than 100 days. On the other hand, learned counsel for the petitioner has also cited a ruling of Madhya Pradesh High Court in the case of Raja Bhaiya Singh versus State of MP, where to State of MP within bracket criminal revision number 1813/2020 in support of submissions made by him. On the other hand, learned counsel for the learned additional public prosecutor, Mr. P.S. Lakar, has produced the case diary of South Salmara PS case number 200/2024 and has submitted that the FSL report of the sample sent to the forensic laboratory has been received. And according to FSL report, the the contraband which was seized from the house of the petitioner is found to be cannabis slash ganja.
Yeah, within the cannabis, within bracket ganja.
Cannabis within bracket ganja. Stop. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of the South Salmara PS case number. What is the case number? Case number 200/2024, which was produced by the learned, which has been produced by the learned additional public prosecutor. Stop. On perusal of the records, it appears that the main accusation against the petitioner is twofold. Firstly, he has been accused of indulging in large scale of cannabis cultivation. The offense, the unauthorized cannabis cultivation is prohibited under section 8 of the NDPS Act 1986, and it has been punished. It has been penalized, and penalty has been prescribed. Punishment has been prescribed under section 20 within bracket small a /20 within bracket small b clause within bracket small 1 of the NDPS Act, which provides for the maximum punishment of, provides for an punishment of rigorous imprisonment for a term which may extend to 10 years. Thus, on plain reading of the penal provisions, it appears that the statutory period of detention for offense under the aforesaid provision under section 187 of BNSS would be 60 days only. Similarly, for
90 days.
60
Oh,
days.
60 days. Regarding intermediate, it is
60 days. As regards the contraband which was recovered from the residence of the present petitioner,
No, my lord. Residence of one Bulu Rahman,
His son of the
son of the petitioner.
residence of the residence of the son of the present petitioner is concerned, same also falls within the weight of same also is less than commercial quantity, and therefore the offense involved would be under section 20 small b small Roman 2 capital B of the NDPS Act, for which offense also, for the said offense also, the maximum period of detention under section 187 of BNSS is 60 days. So, in view of above, no, the petitioner has already been detained for more than 100 days. And in view of the facts discussed above, he is entitled to get bail in this case. The petitioner is therefore allowed to go on, the petitioner, namely Lal Mia, is therefore allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned Special Judge South Salmara Hat Singh Mari, with following conditions. Conditions apni loi logo from Munwal. With following conditions. This bail application is accordingly disposed of. Send back the case diary.
Obliged.
My lord, I am already on 51 days. In case of my lord, 60 days, my lord. The two admit cards have been found in my possession, my lord. One is with my corrected
Yes,
name.
there is there.
Yes, there is, dear lord. Already
Yes.
51 days, I have already lost the job, my lord.
What is the progress?
Lordship, in this case, Lordship, the present, in the name of the present petitioner, he has been applied in two names, Lordship. His original name is Sadek Ali, and he has applied in the name of Sajid Ali, Lordship. And moreover, he has also made a fake Aadhaar card, Lordship. And in that Aadhaar, that person is also arrested, Lordship. And he has also stated that the person who has made this fake Aadhaar card, Lordship, that he earlier used to do this type of things, Lordship, but he has not neither denied nor accepted, Lordship. Moreover, he has accepted, his statement is also there, in otherwise material is there, Lordship.
But before the examination, he was apprehended. He couldn't appear in the examination, my lord.
Okay, heard Mr. A. M. Bora, learned senior counsel assisted by Mr. V. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Sadek Ali alias Sajid Ali, who has been detained behind the bars since 2025 within bracket for last 51 days in connection with Tejpur PS case number 44/2025 under section 319 within bracket 2 of BNSS, read with section 10 within bracket 2 of the Assam Public Examination within bracket measures for prevention of unfair means in recruitment bracket close Act 2024. The gist of accusation in this case is that on 19th January 2025, one Rupam Bora, principal of Government Girls High School, Higher Secondary and MP School, Tejpur, had lodged an FIR before the officer in charge of Tejpur Police Station, inter alia, alleging that on 19th January 2025, while conducting TET recruitment examination in their school, a complaint was received that one candidate is appearing in the examination with fake identity card. On tracking the candidate, it was found that it was the petitioner with roll number 901340, which was found to be fake. The petitioner okay, so it was alleged that the petitioner has resorted to malpractice in examination, and accordingly, Tejpur PS case number 44/2025 was registered. Learned senior counsel for the petitioner has submitted that the petitioner has already undergone detention for last 51 days, and he also did not appear in the said examination. And considering the period of detention, he prays that the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor has oppose the grant of bail to the petitioner on the ground that sufficient incriminating materials are there in the case diary. He has produced the case diary of Tejpur PS case number 44/2025. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. Though there are incriminating materials against the present petitioner in the case diary, however, considering the progress of the investigation as well as considering the period of detention undergone by the petitioner, this court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation. Hence, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Sonitpur, Tejpur, with following conditions: number 1 and 2. Send back the case diary.
Deeply obliged.
I'll take one short break.
Two occasions date of date, but today I believe on its way it's coming. Can it be after some time? The case diary is coming. We are already 88 days behind.
What is your prayer? What is your prayer?
Lordship, CD is coming. Kindly pass over the matter for time being, Lordship.
For time being?
Time being.
Time being,
Okay.
Lordship.
Highly
Yes, sir.
obliged.
What will rise early? Notice the. Yes.
May I please, Your Lordship? On last occasion, my lord, prayer of the present petitioner's bail was rejected by this honorable court on 26th of September, my lord, in connection with this case. Thereafter, my lord, 5 to 6 months is almost elapsed. No PWs have been examined in the learned trial court.
Scan copy not recovered.
And they are behind by my lord since 1 year, 8 months, 15 days.
Let the scan copy arrive. We will issue reminder for scan copy. Heard Mr. A. Paul, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Office note dated 7/3/2025 shows that the scanned copy of the records of the trial court has not yet been received. Issue reminder for the same. Let this matter be listed again
Very short date,
on
24th.
24th.
Status report is also called.
Scan copy, issue reminder for scan copy along with the status report of the trial. Let this case be listed on 24th of this month.
We are also Lordship scan copy call. Not come.
None has appeared for the applicant petitioner on call. Oh, you are
Same.
same order,
Same.
24th, same order.
Item 51 from supplementary.
Yes.
In this case, my lord, last order, my lord, kindly say, my lord. And as per report from the session judge, my lord, the victim is turned up to receive evidence, my lord.
Whether victim has been examined,
No, not examined, as per report.
report
And
has,
petitioner behind bars 369 days. my lord. Until and unless he is got bail, my petition got bail, the victim is not turned up. my lord. And here is case means POCSO 10 million, it is not 6-4 million.
yes, what is your submission?
11 years old girl, my lord.
11 years old.
11 years, my lord, and she was, my lord, she was put, the accused put her
on our left, my lord, and my lord, he touches our private parts.
Kindly see the FIR, my lord, page 8.
No, what is to be done? The victim is not turning up.
My humble submission, my lord, there is no delay, my lord, because 6/3/2024, my lord, he was arrested. Then,
Whether report has come from the,
yes, report has come, my lord. That is in the scan copy of the record.
7/3. Heard Mr. R. Dev. R. Dev. R. Dev, learned counsel for the petitioner, also heard Mr. R. J. Barua, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this matter be listed again on
1/4, my lord.
1/4 for case diary.
Mr. Lordship.
Police services, central. My lord, SGM and Deputy Solicitor General of India will appear. Union of India.
Who will be appearing?
RK student.
Why? This is a
Because it is
CBI case.
Union of India, my lord.
Now, what is the status?
Yes. The petitioner intend to appear before the cyber police.
You have appeared, you have produced the case diary. Case diary shall have to be produced by, what is,
That is not received, my lord.
yes, what is your submission?
Lordship, the accused petitioner is not involved in this case, your lordship. In this regard, the accused petitioner already filed a written objection before the cyber police station, Goalpara, your lordship. Page number,
This is with regard to a case which is pending in Andhra Pradesh, Vijayawada Police Station.
page
And
number
his
6.
prayer was, my lord, to release the accused to go on transit period bail, my lord.
This is an transit
If he has already appeared, my lord, then if he is not arrested, my lord. I do not know, my lord, what are the matters, because my lord, case diary, my lord, it is not related to, my lord, this state, my lord.
Yes, what is your submission?
Your lordship, the accused petitioner now intend to appear before the cyber police station to cooperate with the police.
The cyber police from Vijayawada. Vijayawada airport can be bail.
Transit and civil.
Transit bail can be granted, my lord, but I do not know, my lord, in Union of State also party, my lord.
No, here is another. Yes.
Where is the law? "41A notice has been issued against you.
Yeah.
So why are you apprehending arrest? They will not arrest you, therefore they have issued
If
41.
the cyber police, when they arrest me, that's why I.
My lord, he has obtained an order, my lord, I do not know, my lord, how this order will help him, my lord.
What order?
It is a transit bail, my lord.
From which court?
Coordinate bench of this honorable court.
You show me the law that transit bail can be granted for an case which is pending outside the jurisdiction of this court.
But in this regard, the honorable court can grant it.
Yes, you show me the law. Come prepared. Heard, Mr. What is your name? R. Ali, learned counsel for the petitioner. Also heard Mr. R.J. Burwal, learned additional public prosecutor. On request of learned counsel for the petitioner, this matter is listed on when? 18th, 17th,
Your Lordship,
on 18th of March, 2020.
wait, please, Your Lordship. But last occasion, Your Lordship, respondent number 2 had filed their affidavit, my lord. The affidavit says, but same as the my lord, FIR, my lord. May I read the
You
FIR?
are opposing.
FIR is at page 33, my lord. It is the vernacular. May I read, my lord?
What is the accusation?
The question is that I have caught hold of the minor girl, my lord. That is the allegation, my lord. Only physical assault, my lord, not any whisper of the sexual assault in the FIR, my lord. আসামি মোৰ ছোৱালীৰ হাতত খামোচ মাৰি ধৰে আৰু শাৰীৰিক নিৰ্যাতন of my FIR, my lord.
When you filed FIR?
Of my FIR, my lord.
When you filed FIR?
Same date, my lord. There is the same, my lord, page 25. My wife has lost the FIR, my lord. Page 25, may I read, my lord?
No. At what time you, on 15/11,
On 15/11, my lord.
and FIR against you?
FIR against me plus same date is same, my lord. My FIR is registered prior to the FIR lost by the informant, my lord.
Yes.
My FIR is 194, my lord. They are 195, my lord. May I read the allegation, my lord? Page 33, my lord. This section 12 has been added, my lord. It is a, if the, we go by the FIR, my lord, section 12 is not attracted, my lord.
Section 12
Is a POCSO, my lord. May I read, my lord?
sexual assault.
No, my lord.
What is section 12?
Here, I filed for lawsuit suspension of the sentence, lordship. And the petitioner was convicted under 4 of the POCSO, lordship. Although, lordship, there are 4 person has been convicted. Out of them, lordship, 2, 3, and 4, lordship, they are convicted under 366A, lordship, and they approach this court, lordship. On their approach, lordship, their sentence was suspended, lordship. That order I have annexed, lordship.
Where?
That is on page 42, lordship. They are convicted under 366A, but this present appellant, lordship, convicted under 4 of the POCSO, lordship.
Penetrative sexual assault. What is your ground?
Ground, lordship, is
What is the punishment?
10 years, lordship, here. And this petition appellant in jail custody, lordship, 2 years, 1 month, 3 days, lordship. That is 756 days, lordship, if I'm not wrong.
No, that is not material.
Yes, lordship. But lordship, now lordship,
We have to file objection, my lord.
You file objection.
We have not filed, my lord. Sometime may be granted, my lord.
Heard, Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Burwal, learned additional public prosecutor. This application under section 430 of BNSS 2023 has been filed by the applicant/appellant Mohammed Saddam Hussain, praying for suspension of the sentence imposed on him by the judgment which has been impugned by the applicant by filing connected criminal appeal, that is criminal appeal number 248/2023. Learned additional public prosecutor submits that the state intends to file a written objection against the prayer for suspension of sentence made by the applicant, and hence prays for some time for filing the same. Prayer is allowed. Let- let-
34.
Let this matter be when, how much?
28 March, my lord.
Let this matter be listed again on 20th March. What is 34?
34, the two petitioner is there, they are already in bail. Therefore, matter may be fixed for hearing, my lord.
Hearing in the normal course.
Yes, my lord.
Otherwise, the 34 and 35 relates to same matter.
33 and 30.
33 and 34,
34.
same judgment.
Same judge.
Okay. Both cases may be fixed for hearing.
Lordship, this petitioner in jail custody for lordship.
No, maybe
applicant lordship.
that will be decided separately
Separately, remember.
on 20.
There is no reason for that.
Heard Mr. B. Chaudhary in appeal, criminal appeal number 248. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Burwal, learned additional public prosecutor. The records of the trial court have been received and this case is ready for hearing. Let this matter be listed for hearing after 6 weeks on a date to be fixed by registry. Same order. What is your name?
G.U. Ahmed.
J.U.
G.U. Ahmed.
G.U. Ahmed. In criminal appeal 60, appellant's name belag hoga, baki hai.
Lordship, may I pray, lordship, date may be fixed,
No.
lordship. Because lordship, this appellant in jail, lordship. And they are on bail.
Your interlocutory application has been given a fixed date.
That can be reflected in the order. lordship.
No, that has been mentioned in the I-28.
May feel law. My lord, this hyper suspension of the sentences, my lord, the last occasion, my lord, the additional people took time for filing their petition, my lord. But if not, two occasion, my lord.
My lord, I have checked, my lord, opposition not file, my lord. So I pray to my lord,
Custody, my lord,
allow some time to file it.
short date, my.
How much time?
My lord, that is 1st of April, my lord.
Heard, Mr. What is your name?
April.
HL, my lord.
H. Ali, learned counsel for the applicant. Also heard Mr. R.J. Burwal, learned additional public prosecutor, as well as Miss, what is the name? J. Begum, appearing for respondent number 2. Learned additional public prosecutor prays for some more time for filing written objection against the prayer for suspension of sentence made by the applicant. Prayer is allowed. Let this case be listed again on first
My lord, he is
My
playing,
lord,
my lord, some
March,
powder.
my lord, March, my lord, before.
27/3, my lord.
27/3.
High level, my. Oh, yes, sir.
Mr. Lord. This criminal petition is under section 482 for passing the
Why it has come up for orders?
is a passment of the minor, passment of the search sheet minor. Search sheet number 53, public 2024, dated 33/2024. Annexer Act in page number 42 to 49.
Okay, case diary has been received. Heard Miss B.R.A. Sultana, learned counsel for the petitioner. Also heard Mr. R.J. Burwal, learned additional public prosecutor. The scanned copy of the case diary, which was called for, has been received. Stop. Let this case be listed for admission hearing. When?
Now that may be fixed and interim prayer may be considered, my lord.
Admission hearing in the first week of April on a date to be fixed by registry.
Under interim prayer, my lord. it
On
will-
that day, your petition will be decided. Finally, it will be finally decided,
That is fixed, my lord. April,
first week of April.
that will be fixed.
Date will be fixed by registry.
47.
In this case, what I have submitted the Uklap Mallet only about two minors, but our names have not been shown by that.
Heard Mr. H. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor. Mr.
As Islam.
S. Islam, learned counsel for respondent number 2 has submitted that Wakalatnama on behalf of respondent number 2 has been filed in this case. However, his name is not shown in the cause list stuff. Registry is directed to reflect the name of Mr. S. Islam as engaged counsel for respondent number 2 in the cause list henceforth. Why it has come up for orders today?
Last one,
Service.
service is complete, my lord.
Records will be necessary.
Records was called for, my lord, on last one. And it should be listed for here, admission hearing.
Records aisene
Record not received. my lord.
on perusal of office note dated 3/3/2025. It appears that the scanned copy of the records which were called for in connection with this case has not yet been received. Issue reminder for the same. Release this matter after 2 weeks on a date to be fixed by registry after receipt of the records of the trial court.
As per my information, record is already received yesterday.
Registry will verify that.
You have a
Alright.
strong information network. After 1 week, 2 weeks. Bitha ko.
Always.
Document typing আছে episode
May I please, your lordship? My lord, we are in custody for 88 day,
how many
88 day, 21C.
date of arrest is
Date of arrest is, my lord, 14/12/2024, my lord.
yes
Now, some heroin has been recovered from one truck and one Fortuner car, my lord.
Yes.
Two vehicle has been apprehended and it was recovered from one truck.
okay
We are in that Fortuner car, my lord. We are traveling along with one of the cousin sister, my lord. But now, lordship, apparently the complaint filed by the DRI itself suggested that we are not in a conscious possession of the item because the lady herself admitted, page 23. Page 23, Roman 5, my lord.
yes
May I read, my lord?
yes
Your Honor, in presence of the gazetted officer DRI, all 5 apprehended person and their person belonging were searched, but no contraband could be recovered from them. Then the DRI officers asked all of the 5 intercepted person to divulge about the narcotic drug concealed in their vehicle, to which they reiterated that no contraband narcotic is in their vehicle. However, on repeated inquiry, DRI officer, is Shoila Stephen Maram, the driver of the intercepted truck bearing number so-and-so, and Srimati Preeti Thaitak, who was seated on the front passenger seat of the Toyota Fortuner car bearing registration number so-and-so at the time of interception, confessed that there were 27 numbers of soft cases containing heroin concealed in a specifically built cavity chamber located between the driver's cabin and the load space in the said truck, madam. And in the Panchnama also, she has admitted that we are just being the cousin of her, and page 44 in the Panchnama also, same facts that we are not in a conscious possession of the contraband. She has admitted and the driver has admitted that it was in the hidden compartment and this person was not aware. As
No,
per
no.
page
If
44.
it is hidden, how you came to know? If it is,
No, they said, madam.
who? The
That the-
petitioner.
No, not the petitioner, the person who travel with me, two person.
Who
One
are
was
the petitioners are three petitioners.
Yes, three petitioners, my lord.
They were traveling in Toyota car.
Yes. And
Okay.
the contraband recovered from the truck.
Okay.
Now, after the interrogation, my lord, everybody was questioned, my lord, interrogated. Then after repeated interrogation, that lady, the one Priti, she and the driver, they have confessed that they have concealed it in the truck and they have accordingly showed it to the person concerned.
Okay.
We are not in, there's nothing in that we are aware of the contraband or we are in connivance with those, my lord. Only though they have admitted them. So in the Panchnama also, same thing,
Page.
page 44. Page 45 is a relevant paragraph. In the second paragraph, my lord. After 8 line in the second paragraph, 45, my lord. May I read, my lord?
Yes.
The DRI officers then asked the three intercepted person of the said Toyota Fortuner car bearing number so why the said car was escorting the vehicle on the close proximity, to which the female person, this is she is not before your lordship, my lord. Priti Thoiku informed that this sole Morak sitting on the front seat and the said Tata truck P. Mapaira sitting in the rear passenger seat of the said Pancher car are her nephew, and the Sail Gurang is a friend of so. These are the three petitioners, my lord. It is her own statement, my lord. On the basis of that, so we are just accompanying her, and they have identified, that lady has herself identified the goods in the hidden compartment, man. After repeated interrogation, man.
Okay.
So we are not in conscious possession, madam.
So you were not aware about.
We are not aware, madam. She has herself admitted that we are not aware. The complaint petition also appears that we are not aware of the fact. We are just accompanying her, being her cousin, madam.
Okay. Anything else?
Lordship asked for the case diary that is there. Lordship, the incident took place on 13/12/2024 and investigation is going on. Lordship, in the meantime, we have received the official report which confirms drugs as a heroin drug. Lordship, with regard to the submission of our learned friend that they were not aware, this is incorrect. Because they were traveling in the both the cars, and Lordship may come to page 23.
Yes.
And learned friend has read out paragraph 5. Lordship may come to paragraph 6. Your Honor, thereafter, in presence of the two independent witnesses, their officers took 5 intercepted persons to the intercepted Tata truck bearing registration number so and so, where an iron sheet measuring approximately 87.6 inches in length and 82.8 inches in breadth could be seen secured with screw on the partition between driver cabin and load space of the said truck. In the absence of the independent witness and the presence of Sri Sahil Gurung, Sri P. Morphin, Sri P. Soel Maram, the DRI officer then asked Sri Salesh Stephen Maram and Miss Priti Tylok to remove all the packages from the said specially built cavity chamber located between the driver's cabin and load space of the said truck. Then Sri Seles Stephen Maram first remove the screw and iron cover plate and remove the said cover plate and inner opening leading to the cavity could be seen. The said cavity was seen filled with the plastic soap case of the assorted colors, each tied with rubber band. Director Sri Seles Stephen Maram and Miss Priti Tailok started removing all the plastic soaps of the assorted color and the said cavity. A total 274 soaps case of assorted color is tied with the rubber band were recovered from the intercepted Tata truck bearing reference number so and so. Then next paragraph, page 24. Thereafter, the said officers opened one recovered soap case and then Lordship may come to seizure list.
Page.
Start from page 31. Inventory and seize memo of the goods seized. Seized under section 42-43 of the Narcotics Substance Act 1985 as a parent so and so, name and address of the owners, 5 persons by whom the seized materials, by whom, then the name of the officer is there. Then below, signature of the owner of the possessor, all 5 have been put their signature in front of the independent witness. All the pages they put their signature.
So what it means?
It is from their conscious position of all the persons goods has been seized. It may be seized from one truck, but they were aware about concealing of this narcotic in the truck. And they were traveling along with the truck.
No, what is the basis?
This is the basis, Lordship, because it was recovered from them. And they stated, I have read out the paragraph.
No, the petitioner's case is 5 persons were traveling.
No.
Two of them.
Two of them traveling in the truck and 3 were following that.
3 were following the Toyota.
Yes, Lordship. So, in my also, this was the conscious position of all these persons. They were aware about the concealing of the drugs in truck lots. And they have put their
No, on what basis you are saying?
Because it was recovered from them on the basis of seizure memo.
No, it was recovered from the vehicle.
It was recovered from the vehicle.
Truck.
And conscious position was because they were traveling along with the truck, Lordship.
Because they were traveling, therefore you are saying.
Yes, Lordship. And this was upheld by the Honorable Supreme Court in Nawaz Sharif's case.
Which case?
In Nawaz Sharif's case, I'll place that judgment. That is reported in 2021-10 SCC page 100. This is what happened. The persons were traveling from Dimapur to Delhi. In between in UP, they were arrested. Then Supreme Court says that
here the contraband was concealed
in a vehicle, Lordship, and they were traveling in that vehicle also.
Okay. What has been held?
It was held that when a person were traveling in the same vehicle, then it amounts to conscious position. It was recovered from them.
Which para?
Let's see my place. Paragraph 30. The following circumstances are crucial to ascertain whether the High Court has correctly evaluated the application for bail having regard to the provision of section 37. The respondent was traveling in the vehicle all the way from Dimapur in Nagaland to Rampur in Uttar Pradesh with the co-accused. The complainant notes that the CDR analysis of the mobile number used by the respondent indicates that the respondent was in regular touch with each other accused persons who were knowing to him. The quantity of contraband found in the vehicle is a commercial quantity. The contraband was concealed in the vehicle in which the respondent was traveling with the co-accused. Here, Lordship, there were 2 vehicles. And simultaneously they were traveling. And that statement has been recorded by the authority, in the investigation that is placed before the lawsuit.
What they have stated? You just tell me, I will go through. We'll continue at 2. You have to point out, his case is that the petitioners, what I have understood,
I am not aware about the
they,
concerning of the.
they were
contract.
traveling in a vehicle which was following the truck,
Yes,
and they were not aware about the fact that the contraband is concealed in the truck.
yes, sir.
And
I'll-
it was revealed by one lady and the driver of the
They were traveling in the truck.
truck.
Yes.
So there is nothing to implicate them. That is his submission.
Yes, sir.
So you have to show me that,
And that is, they have admitted in the complaint petition itself.
and they have not implicated that.
I'll
The,
place materials before the lawsuit.
yes, you have to point out the
Yes, sir.
material.
And lordship, investigation is continuing, final complaint not been filed. This is only a report submitted before the honorable magistrate for taking them to the custody of the law.
Okay, as of date, some materials might be there.
Yes, yes, it is
You
there.
have to show that.
I'll place
at
before the law.
2.
Yes, Lord. Should I read this material parts or place before the law? I flag mark the.
You have flag mark.
Yes, Lord.
What is the material?
Every sufficient materials are there, Lord.
Like,
They are they having a relation with each other. And they
a
admitted
telephonic conversation.
that report has not come. That is, we have sent for. We are asking for the CDR that we are evaluating.
Okay.
Petition number 1 was sitting in the truck. Petitioner number 2 is the brother of petitioner number 1. Then Gurung is a friend of all these 2 persons.
You flag the materials
I
which you
flagged.
think that will
Yes.
help you.
Yes, Lord.
Heard Mr. A. M. Bora, learned
My lord.
counsel.
Just before he comes to that, just one thing regarding the judgment, my lord. One thing is very clear. The judgment itself,
Which one?
the judgment is relied, my lord. In this case, my lord, 2021 10 SCC, page 100, Union of India versus Nawaz Khan.
Nawaz Khan.
Yes. There is the one thing is very distinct and clear. Well, here is the GG entry. In the GG entry itself, well, paragraph 2, all the accused person has been named in the GG entry that they were traveling with the articles, man, already, man.
In the same vehicle.
My lord.
In the vehicle which were they
Yes,
were
my lord,
traveling.
prior there is a intimation, my lord, secret information that these persons carrying articles in the vehicle itself. So there is a GD entry, so tip off is already there, man. So their name has been already in the GD entry in this particular case. So that is why the conscious possession comes into play, my lord. Because GD entry says all the accused person names in the paragraph 2. May I read, my lord?
Yes.
The complaint was filed on so-and-so through the intelligence officer of Lucknow of the narcotic bureau. The allegation is that the NCB zonal unit received the information that 1400 hours that the 3 persons, namely Arif Khan, Rafiuddin and Nawaz Khan, the respondent, who are residents of Manipur, were proceeding with the heroin morphine. So there already an information that these Nawaz Khan and the others, they are proceeding with the heroin, my lord. They have the information in this case, my lord. So that is why this has been rejected, because there is no case of conscious possession comes into play, because already a tip off that this person is carrying. Then, and secondly, the paragraph 6, that there is a CDR report in that case. In the paragraph 6, between them, they were communicating each other in the CDR report, paragraph 6.
Paragraph 5.
5 and 6, my lord. 6, my lord, Placitum A, the CDR analysis of the said mobile numbers indicated that the respondent was regularly corresponding with the co-accused, one of the Anis so-and-so, who is a resident of Dimapur, is also suspected to be involved in the drug trafficking. Then the paragraph 10, the learned my lord Solicitor General,
Which judgment yours?
this is my lord the
Nawaz Khan.
Yes, Nawaz Khan.
Para 10 is a different.
Whether Lordship is taking the SCC copy? No, this is.
No.
Oh, that is why the
Okay.
probably my lord.
Okay, no, you read the para, I will. Para?
I am reading my lord, the first is regarding my lord, paragraph 2 regarding there is a GD entry which starts with the line that the complaint was filed in 16/9/19.
Yes, yes.
That is the paragraph 2. It says there is a prior information regarding involvement of all the accused person, my lord, that they were carrying the narcotic. So conscious possession already been proved in the secret information itself. The paragraph 2. Then Lordship kindly seek the paragraph in the next, the letter dated 10/7/19.
Yes, para 5.
That is para 5 in Masjid. The para 5, my lord, the CDR report, Placitum A, third line, my lord, the CDR analysis of the said mobile number indicates the respondent was regularly corresponding of the co-accused and one of the Anis Elias Abbas, who is a resident of Dimapur and is also suspected to be involved in the drug trafficking. So they are already communicating one with the drug traffickers, my lord. That is the analysis says. They are in constant touch with one of the drug traffickers who is suspected. So that is the, then now, my lord, the para probably 9, my lord, SB Raju. Mr. SB Raju, my lord. Probably Lordship in para 9.
Yes, para 8.
Para 8. So SB Raju's, he has not relied on the statement of the Tufan, the co-accused statement and the confessional statement, because there is a bar in the Tufan Singh's case that has been admitted. But his case is that then again, Lordship will find the apart from the above, in my paragraph 13, maybe it will be, my lord, 10 or 12, my lord.
10.
Yes, apart from the above circumstances, it has been submitted that the respondent, after having released on bail, was constantly avoided the appearing before the session judge at Lucknow, as a result of which the charges could not be framed and eventually non-bailable warrant has been issued against the respondent. That is one of the circumstances decided by the Supreme Court while rejecting the bail. So here also the Supreme Court has said regarding the conscious possession, it will depend upon the facts to facts, my lord. It is not in a blanket judgment. There can be a blanket, cannot be a blanket judgment that just because they are traveling in the same, they all are having the conscious possession. It will depend on the facts to
No,
facts.
but in your case,
My case is that
the
two trucks.
contraband was not found in the vehicle in which you are traveling.
Yes, and the main person, they have confessed and they have actually identified from the secret cavity. Two person, in driver and the lady, Mary.
And the petitioners were traveling in?
One is truck, one in the truck, the rest were in the Fortuner.
Oh, one of the petitioner was in truck.
POCSO number 1.
So, but when they were interrogated, their case itself, my lord, the paragraph, Lordship kindly see the paragraph, their complaint petition itself. I am repeating the
No, okay.
page 23 of my petition.
That you are not named by the co-accused.
Yes, here others said that they are not named by the co-accused. Similarly, the paragraph 6, which he has read it, but in that also there is no implication to us, my lord. Nowhere there is an implication that we are in conscious possession in their complaint, or there is a conspiracy with them. There is nothing to show in the complaint petitions. Rather, in the Panchnama also, it is evident that the lady and the driver When they were interrogated, they took the police and they have recovered the contraband from the secret cavity of the truck. And she said they are my cousins. That is only that much. She has not stated that they were also with me. They were aware of the fact that we all are carrying. This is absolutely silent, my lord. So there is no material to that effect. And he is relying on that the CDR report, which is not before your lordship and neither that before them till date. It is 88 days.
Okay, heard Mr. A.M.
Lordship,
Bora.
just for,
Yes,
if you Lordship allow, I can.
yes, yes.
With regard to judgment, Lordship, and the materials, I'm just reading one paragraph that will clarify everything. It is from the note sheet.
From
From the note sheet of the case diary.
note sheet of the case diary.
Yes.
Okay.
Then we asked both the intercepted persons of the said truck bearing registration number so and so, whether they were carrying any contraband narcotic drug in the said truck, to which both the intercepted persons said that the Tata truck denied having any contraband narcotic drugs in their vehicle. Sohel Maram, petitioner number 1, sitting in the front cabin seat of the said truck, informed the DRI officer that the female person sitting in the front passenger seat of the said truck Fortuner car is his aunt, named Priti Toytak, and P. Marpia, sitting on the rear passenger seat of the said Fortune car is his brother. DRI officers then asked the 3 intercepted persons of the said Toyota Fortuner car bearing registration number so and so, why they said the car was escorting the vehicle on close proximity, to which the female person, Priti Talog, informed that the Sol Maram, sitting on the front seat cabin of the said Tata truck, and P. Moran sitting on the rear passenger seat of the said truck are her nephew, and Sahil Gurung is friend of Soil Maram. We asked the 3 intercepted persons of the said car whether there are any contraband narcotics in the said truck bearing registration number so and so, or in the said Toyota Fortuner car bearing registration number so and so, to which they denied initially. Then, thereafter, we informed both the intercepted persons. Now, Lordship may please to not probably count this judgment. The same thing is here. The said truck bearing registration number so and so, and 3 intercepted persons of the said Toyota truck bearing registration number so and so, that we have specific intelligence that narcotic drugs are being carried in the said Tata truck bearing registration number so and so. That the 3 intercepted persons in the said Fortuner car bearing registration number so and so are escorting them for delivery of the narcotic drug, and all the 5 intercepted persons are the part of the single syndicate narcotic trading and smuggling, to which the 5 intercepted persons denied. Thereafter, it was found out and they put their signature in the charts.
No, we are not denying regarding the seizure of the property.
No,
my lord.
Lordship,
That's why the signature.
And Lordship, I'm intercepting. Lordship, they were arrested just in the month of December. The investigation is going on, and we are.
That's a different issue, my
No,
lord.
no, we are getting 180 days to complete the investigation.
That is.
And Lordship, the statement of Mr. Sovel.
Now, how many days you are behind the bar?
88 days. As on today.
And as per law, we are getting 180 days as well as
I'm not denying all those things, my lord, legal provisions. My question is that whether their complaint petition indicates our involvement is that all the co-accused is rather implicated that we are also traveling. Where from this come into position that this simply because we are coming behind that truck, it indicates that we have in the conscious possession. Where from that material has come. That material has to come from some, there has to some material after 88 days.
In a statement, it is their message.
That is the statement. That is why saying that this case, the learned the Solicitor General, he rather said that I cannot rely on the statement of the accused because there is a bar. In that particular case, he is relying on.
Lordship, for investigation, there is no bar.
No. He himself said. Lordship can say. No. He may say that this is your officer. He himself, the Solicitor General, relied on that particular judgment that I cannot rely on the statement of the confessional statement because there is a bar as per the judgment of the Tufan Singh.
153 of Tufan Singh.
And this is the 439. And the Tufan Singh is very clear. In 439, you cannot.
438, yes. For the purpose of investigation, the co-accused statement is relevant, 438. But 439 there is a specific bar and their officer, Mr. S.B. Raju, Solicitor General, in paragraph 10 of that judgment, is categorically state that I cannot rely on the co-accused judgment because of the bar of the Tupansi.
And he admitted in his statement that he is involved in this racket to earn the money, handsome money.
Okay. Heard Mr. A. N. Bora, learned senior counsel, assisted by Mr. V. H. Chaudhary. Also heard Mr. S. C. K. R. learned standing counsel, DRI. DRI.
DRI.
DRI. This application under section 483 of BNSS, 2023 has been filed by the petitioners, namely P. Sol, P. Maraipa, and Sahil Guru, 1 to 3, who are detained behind the bars since 14/12/2024 for last 88 days, bracket close, in connection with DRI case number 21/CL/NDPS/Heroin/DRI/GZU/2425 under section 8C/21C/22C/23C/25 of the NDPS Act. The gist of accusation in this case is that on on 13/12/2024, on receipt of a information through reliable sources by the officers of DRI Guwahati Zonal Unit that a truck bearing registration number AS25 EC 3517 carrying 2 male persons and closely escorted by one white-colored Toyota Fortuner car bearing registration number UK07 BS0189 carrying two male person and one female person are coming from Jorabat side. A team of DRI officers, were constituted, and a search operation was conducted. The search team intercepted one Tata truck bearing registration number AS25EC 3517, where the person sitting in the front cabin of the said truck was identified as P. Sol Maram, within bracket the petitioner number 1 in this case, as well as one Sahil Guru, who was the driver of the said truck. No. As well as who was the driver of the truck?
Driver of the truck is
Shailesh Stephen Maram, who is the driver of the said truck. The search team also intercepted one Toyota Fortuner car bearing registration number UK07BS0189, and the occupant of the said vehicle were identified as Sahil Guru and one Priti Hoitak and P. Marpia. Stop. During search of the said truck, during interrogation of the occupants of the vehicles, Salesh Stephen Maram, that is the driver of the said truck, and Miss Preeti Thoitak revealed that there are 274 numbers of soap cases concealed in specially built cavity / chambers in the driver's cabin of the said Tata truck. Accordingly, a search was conducted and 274 soap cases containing about 3180.83 grams of suspected heroin was seized. Learned counsel for the petitioner has, learned senior counsel for the petitioner has submitted that the petitioner number 1 was traveling in the truck from where the contraband was seized. However, petitioner number 2 and 3 were traveling in the Toyota Fortuner car from where nothing was seized. He further submits that the complaint filed by DRI would reveal that the two occupants of the driver of the truck as well as one of the female occupant of the vehicle revealed regarding concealing of the seized contraband in secret chambers in the cabin of the truck, and they have not implicated the present petitioners in any manner. Learned senior counsel for the petitioner has submitted that the petitioners were unaware about the fact that the truck which was seized in this case was carrying contraband in hidden chambers. So, learned counsel for the petitioner, learned senior counsel for the petitioner further submits that as the petitioners were neither in constructive possession nor in conscious possession of the contraband seized in this case, there is reasonable ground to believe that they are not guilty of the offense offense alleged in the complaint petition filed by the DRI. Any other submission? Conscious possession
And the complaint petition itself is silent regarding that the
yes.
conscious petition of the
Yes.
petitioners. my lord.
He further submits that in the complaint filed by DRI, there is no accusation regarding the conscious possession of the present petitioners of the seized contraband. He therefore submits that the petitioners are entitled to get bail in this case. On the other hand, Mr. S.C. Kayal, learned standing counsel DRI, has vehemently opposed the grant of bail to the present petitioners on the ground that the seized contraband was recovered from the conscious possession of the present petitioner as as it would be as apparent from the seizure list, where all the petitioners have put their signatures at the time of seizing of this recovered contraband. Learned counsel for the petitioner, learned standing counsel DRI has produced the case diary of DRI case number 21 dash case number data, and has submitted that the investigation is still going on and there is every possible and there are materials against the petitioners in the case diary which would implicate them in the offense alleged in the complaint petition. He also submits that he also, learned standing counsel DRI also relied on a ruling of the apex court in the case of Union of India through NCB versus Nawaz Khan, reported in 2021 10 SCC 100, wherein the apex court has observed that if the contraband is seized from the vehicle in which the accused persons were also traveling, it can be held that the accused persons are in conscious possession of the seized contraband. In Nawaz Khan, which paragraph you are relying?
There is no specific parameter.
Paragraph 30.
Para 30.
Paragraph 30 key start is
The following circumstances are crucial to assessing whether the High Court has correctly elaborated the application for having.
I have considered the submission.
Lordship, I have also submitted
Learned-
case diary along with one judgment on conscious position recently. What is the meaning of conscious position and how to be dealt in the narcotic case?
Learned standing counsel DRI has also cited a ruling of apex court in the case of Rakesh Kumar Raghuvanshi versus State of Madhya Pradesh, wherein the apex court has
Paragraph 18 order.
dealt with the meaning of conscious possession in an offense involving NDPS case. Stop. I want the case diary.
Case diary is there. I have flagged the
I have
relevant.
considered the submissions made by learned counsel for both the sides.
He also relied on the statement of the co-accused, which I have refuted.
Or the petitioner also. Not the co-accused also.
One more thing. Learned standing counsel for the petitioner has, learned standing counsel for the NCP has also submitted that in the statement recorded under section 67 of the apprehended accused persons, there are implicating materials. And he also submits that though in the case of Tufan Singh versus State of Tamil Nadu, the statement cannot be used as an evidence in a trial of offense involving NDPS Act. However, same may be utilized by the investigating authority during the stage of investigation.
My submission is paragraph probably 9, my lord. In
So-
that particular judgment, SB Raju. Mr. SB Raju, my lord. This case is also, my lord, during investigation.
No. Any complaint was filed?
Yes. There is no trials has started.
In this case also, no trial has started, my lord.
To
Because
counter
charge was not framed admittedly because of they have absconded.
one in the
Here investigation is
in
continuing.
the submission of counsel for petitioner, learned senior counsel for the petitioner has submitted that the only material which might be there in the against the petitioner may be the statement of the apprehended accused persons recorded under section 67 of the NDPS Act, which he submits that cannot be used against the petitioner in view of the decision of Tufan Singh versus State of Tamil Nadu, reported in 2021 4 SCC page 1.
And also, my lord, in this case also, the learned Solicitor General also endorsed the same view, my lord.
Okay.
That the prohibit-
I have marked it. Tomorrow I will deliver the case.
Smile.
Case diary, Lordship, I will-
Till tomorrow it will be with me.
tomorrow. Lordship, it may be kept in the record.
Okay. Heard Mr. A.M. Bora, learned counsel for the petitioner, assisted by Mr. V. H. Chaudhary. Also heard Mr. S. C. Khan, learned additional public, learned standing counsel, DRI. List this matter for delivery of orders on 12th of March 2020. On 13th of March, 13th of March, day after tomorrow.
Obliged.
Lordship, I am leaving the case diary. for-
Case diary recorder logot rakhi.
Wait, please, your lordship. Lordship, this is a anticipatory bail application, second time, lordship. FIR lordship will find on page 14, lordship.
Second time on what ground?
That lordship, last lordship rejection order, that is on page 23, lordship. Page 23, in page 25, lordship, paragraph 7, lordship.
What is your name?
There is petitioner Noor Ahmed, lordship. And Kamal Ali, lordship. Noor Ahmed Ali and Kamal Ali, lordship.
Yes.
At this
There are
stage-
materials against you.
At this stage, lordship, immature stage of the investigation. It
Case
was
diary is
very-
there. We'll call for, we'll call for the case diary.
Yes, lordship. In the
Ah.
meantime, lordship, the informant has lordship sworn an affidavit, lordship, though both them, lordship, that I have annexed.
Okay, heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner for the second time, apprehending his arrest under in connection with Hajo PS case number 222/2024 under section 325/307/302/34 of the IPC. Considering the allegations leveled in the FIR, perusal of the case diary would be necessary, hence call for the case diary.
Along with the
Fixing-
lordship postmortem report, lordship.
along with the postmortem examination report. When? Let this case be listed
24, my lord.
on 24th of March.
Highly obliged.
Wait, please. Lordship, his application is directed assailing a criminal proceeding, lordship, initiated by an order dated 7/2/2024. Lordship.
Whether notice is served,
Lordship, regarding notice, we have taken steps twice, lordship. And lordship may kindly peruse, office note dated 29 of January 2025. There's a notice was served through District Magistrate Lakhimpur on 7th of January 2025. And thereafter again we have taken steps. Notice is served but
Notice is not served.
Lordship, that is the second one. Lordship. Lordship, may kindly peruse 29 January office order. Lordship.
It only says that notice is issued. Regarding service of notice, there is no report. Issuance of notice and service,
Through district magistrate, it is.
it has been issued, but there is no service report.
Lordship, we have taken twice, but perhaps she's not appearing. But in the meantime.
It is a POCSO case.
No, it is under section 493, I consider.
You have to, we have to wait till
Lordship, apart from the merit of the case, there is a specific bar to take cognizance without a complaint.
not without notice. First, you overcome the notice. Ensure that notice is served.
Refer 29 January 2025 office order, Lordship. There is a specific, I have noted down, Lordship. Notice is served through district magistrate.
Not served. It is, notice is issued. Heard, Mr.
Lordship, in the meantime, may I praise for an interim order, Lordship. Otherwise, there is evidence, that is fixed for evidence. Even the FIR is taken as true. Even then the offense doesn't constitute offense under section 493 IPC, Lordship. We have already provided one judgment, Lordship. For a moment, if your Lordship.
No, not without issuing notice. Because this is the fourth date. Issue notice through the jurisdictional police station. Heard, Mr. What is your name? R. Islam. R. Islam, learned counsel for the petitioner. Also heard Mr. R.J. Bawal, learned additional for the prosecutor. On perusal of the office note dated 7/3/2025, it appears that notice issued to respondent number 2 has not yet been received back. Issue. It appears that the petitioner has been taking steps for issuance of notice on the respondent on several occasions. However, same could not be served till date. In view of above, let the notice be issued to respondent number 2 to be served through the officer in charge of North Lakhimpur Police Station. The OC of North Lakhimpur Police Station is directed to return the service report through the learned public prosecutor before this court. The petitioner shall take steps for issuance of notice to the respondent number 2 through the within 3 days from the date of this order, routed through the registry of this court. The notices be returnable on.
Lordship, kindly fix a date prior to 24, Lordship. I'll take the step today itself.
On 21st of March.
Obliged.
May I please, Lordship, a delay of 68 days is there in preparing the connected leave petition and the criminal appeal matter. Notice may go, my lord, at this stage.
Lord Mr. A. Tiwari, learned counsel for the applicant. This application under section 419 within bracket 4 of BNSS has been filed by the petitioner seeking leave to appeal against the judgment and order dated 8/10/2024 passed by learned judicial magistrate first class Kamrup Metro in CR case number 4176/2018, whereby the respondent number 2 and 3 were acquitted of charges under section 138 of Negotiable Instrument Act. Issue notice to the respondent. Since learned additional public prosecutor has appeared for respondent number one, no formal notice need to be issued to the said respondent. As against respondent number 2 and 3, the petitioner shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Well, there is a condonation application also, my lord. 219, my lord.
Condonation of
Yes, my lord, 60 days, my lord. In that, my lord, notice has to be issued, my lord, prior to that.
condonation in filing the leave application.
Leave and criminal appeal, my lord.
Then first condonation has to be
Yes, my lord.
disposed of.
Condonation has to
Then this order will not go,
not go, not go.
not in leave. I go to category. Heard Mr. So-and-so, Atal Tiwari. This application under section 5 of the Limitation Act 1963 has been filed by the applicant praying for condoning the delay of 68 days in preferring the
Connected leave petition and the.
preferring the connected leave petition as well as preferring the connected leave petition to appeal against the judgment and order dated 8/10/2024 passed by learned Judicial Magistrate First Class Kamrup Metro Guwahati in NI case CR case number 4176/2018. Issue notice to the respondent. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued. As regards other respondents, the petitioner shall take steps for issuance of notice upon the said respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable after 4 weeks. Within 7 days, returnable after 4 weeks.
Deeply obliged, Lord.
May I please?
Yes.
This is leave application, my lord, appeal against acquittal. So at this stage, I please notice.
Same order issued. AK order homo. Heard Mr. AK Gupta, learned counsel for the applicant. This application under section 415 within bracket 4 of sorry, 419 within bracket 3 of BNSS, praying for grant of leave to file an appeal against the judgment of acquittal dated 24/12/2024 passed by learned additional Chief Judicial Magistrate in CR case number 42C/2024. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
All right.
Meet resolution as per official data or physical.
I'm appealing. Lordship, I have filed a Vakalanatama yesterday, Lordship. That has not come, but I'm appealing for the respondent number 2. Lordship.
Today is the date for consideration of interim, lordship.
Today is the date for
In consideration of India, as per last order, that is my lord, 6/10/2025. Lordship has observed that the interim will be considered on the next date on Saturday.
where is that observation?
10/2/2025, lordship, on the last line.
What is the submission?
And Lordship, the thing is that the petition is not maintainable like that. This is an act proceeding, Lordship. There now the case is fixed for DW. Now the accused has to adduce evidence.
There is no, kindly lordship, come to the page number first, page number kindly.
What is your interim prayer?
Because the original complaint case is of 2019 lordship. Complainant has been crossed. He issued the check. There is no dispute. Statutory notice was given, no dispute. Towards enforceable liability, he is admitted. And
We'll fix the matter for admission hearing. Argue on that day.
But on the next date is on 18 lordship. Before that lordship may fix the matter on 17 lordship. Lower court on 18 March lordship. If possible, must be 17 lordship.
Heard, Mr. What is your name?
H. Rahman lordship.
H. Rahman, learned counsel for the petitioner. Also heard Mr.
B. Sharma lordship.
B. Sharma appearing for respondent number 2.
Yes.
Whether records would be necessary.
Yes, my lord, the record may be qualified. Can go to LCR.
B. For consideration of the instant criminal petition, this court is of considered opinion that scanned copy of the. What is your ground?
My lord, we are submitted an application for my lord to calling of the my lord bank statement. I which account they have
Then
submitted.
scan copy is not necessary.
My lord,
Necessary, lordship. Lordship, if you come to the lordship.
Let this case be listed for admission hearing
Yes, lordship.
on
17th of March.
on 17th of March.
Yes, lordship. No, yes. I'm ready. Lordship.
On 17th of March.
Yes.
Interim will be considered on the next date. My lord.
It will not be considered.
It's not required, lordship.
You try to.
Section 91
Fine.
petition at this
It
stage
will be
is
finally heard
right.
on that.
Yes, you can lordship can hide on the 17th.
You press for final disposal on.
Yes, lords. Yes, lords. That is required unless it 2019, 139 NIAC provision is there.
Okay, on 17th.
Yes, lords. 17 that it will be an admission. Yes. Oblige.
May I please, Your Lord? And for the petition, my lord.
Why?
We are directed to take statement. We have already taken all the steps.
It is.
Matter as for quashing of a Naraji petition.
Heard
is here.
Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. The office note dated 7/3/2025 shows that the notice issued to respondent number 2 has not yet been served. You'll take fresh steps or we will await.
My lord, we may be awaited because he has already informed because in the concern CR case, my lord,
Okay.
he was present on the relevant
The-
date, my lord.
The service is awaited. Let this matter be listed after 2 weeks on a date to be fixed by registry. The interim order shall continue till next day.
My lord, I beg to draw honorable court's kind attention, my lord. Kindly peruse the last order, my lord, paragraph number 10, my lord. There is a little typographical mistake, my lord. And para number 5 of the last order, my lord.
Para number?
5 of the last order, my lord.
Yes.
Last line, my lord, a complaint case and the CR case number 40/2020 was registered. It should be, my lord, 40/2024. And my lord, para number 12, my lord, same CR case was referred, my lord, as 40/2020. It should be 40/2024, my lord.
So learned counsel for the petitioner has pointed out that a typographical error has crept in the order dated 11/12/2025 passed by this court. In paragraph number 5 as well as 11 of the said.
My lord, 12.
12 of the said order, the CR case number has been mentioned as CR case number 40/2020, whereas it ought to have been 40/2024. Stop. Since the said error is an inadvertent typographical error, same needs to be rectified. Stop. It is therefore same needs to be rectified. The case number, the CR case number mentioned in paragraph number 5 and 12 of the order dated 11/2/2025 shall be read as CR case number 40/2024 instead of 40/2020. Stop. List as a
Not kindly matter may come up after 4 weeks, my lord, if possible, my lord.
2 weeks.
4 weeks.
2 weeks.
Obligement.
Lordship, as per office note dated 7/3/2025, service report is awaited.
Heard, Miss, what is your name?
Isha
A.
Shaha.
A. Saha, learned counsel for the petitioner. On perusal of the office note dated 7/3/2025, it appears that the notice issued to respondent number 1 has not yet been returned, has not yet returned back. Stop. Await further. List this matter after 2 weeks.
And in this case, also notice was issued, my lord. Service report is not complete.
Heard Mr. D.P. Soliha, learned senior counsel assisted by Miss M. Roy, learned counsel for the petitioner. On perusal of the office note dated 7/3/2025, it appears that notice issued to respondent number 2 has not yet returned. We will await or you will take fresh steps. We will wait. Should we wait?
Your lordship pleases.
It was taken in. Await further. List this matter after 2 weeks.
No.
The lordship, my lord, has the appeal, my lord, is against the acquittal, my lord, and the today is the day things, my lord, for combination of delay the miss case and also by the petition.
Heard Mr. Z. Hussain. Z. Hussain,
My lord,
learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant, praying for condoning the delay of 444 days in preferring the connected leave application, seeking leave for preferring an appeal against the order of acquittal by the impugned judgment dated 11/9/2023, passed in sessions case number 41/2019 by the Court of London Additional Session Judge from POCSO, Special Judge POCSO, Kamrup Metro, issue notice to the respondent. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to the said respondent. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD, as well as by usual mode, within 7 days from the date of this order, returnable after 4 weeks.
my lord, from the submission, my lord, this paragraph, my lord, 6, my lord, and typographical error, my lord, the instead of P, my lord, may be allowed to, my lord, come.
Which
In this petition,
in this petition,
my lord, there are 6, my lord. My lord, this DW is mentioned.
learned
instead of
counsel
P.
for the petitioner has submitted that one typographical error has crept in the petition for condoning the delay filed by the petition. Same may be allowed and praise for allowing the rectification of the same. The prayer is allowed.
By hand.
The petitioner may rectify the said error by hand in presence of the court master of this court.
Bless.
May it please your lordship, the lordship received an application for condonation of delay. There's a delay of 87 days in filing the criminal appeal.
Heard Ms. M. K. Brown, learned counsel for the applicant. This application under section 5 of the Limitation Act has been filed by the applicant for condoning the delay of 87 days in preferring the connected criminal appeal. Stop. Issue notice to the respondent. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon respondent number 2. As per the, this is a POCSO case.
Yes, your lordship.
As per the prevailing notification of the registry in this regard, within 3 days from the date of this order, returnable after 2 weeks, list accordingly.
Obliged.
None has appeared for the petitioner on call. List this matter in the next week on a date to be fixed by registry.
May I please your lordship? My lord, in both the matters, my lord, senior advocate A.K. Bhattacharya is appearing. Sometimes before he has left the court, my lord, due to some health.
Heard Mr.
May I-
S. Rabha, learned counsel for the petitioner, who prays for an adjournment on
May
the
I-
ground of difficulty
seek-
of the conducting counsel, Mr. A.K. Bhattacharya. CD is there?
May I seek some accommodation, my lord, day after tomorrow, could it be fixed, my lord?
Next week. Choose any date.
20th March, my lord, 20.
Stop. Learned additional public prosecutor submits that case diary is available. Same shall be retained till the next date. List this matter on 20 March 2020.
Always.
Your lordship, please kindly pass over the matter for the day.
Heard Miss, what is your name? What is your name?
S. Hazarika.
S. Hajarika, learned counsel for the petitioner. Prays for adjourning this case for the day due to personal difficulty of the conducting counsel. The prayer is allowed.
The 482 application for quashing of the
Quashing of
protest petition treated as a complaint. As the order of cognizance taken. My lord will find it.
what is the grounds?
Ground marriage is totally civil dispute and no there is the offense of section 341 and 506 does not attract. I will satisfy you. In this case, what has happened, your lordship? The petitioner number 2 before your lordship has firstly filed lodged an FIR which was treated as a on investigation non-FIR case. The first FIR of the petition number 2, page 14, my lord. Annexure 1, page 14. My FIR was first in time. May I read, my lord? Page 14.
This FIR, no, before that, what are your grounds? You are ready?
My senior is on legs on another court. He's coming.
Who is your senior?
K. Mohammed for respondent number 2.
Let him come.
Can it come up 20th then, after
20th.
20th March?
Heard Mr. What is your name?
G Jalan.
G. Jalan, learned counsel for the petitioner. Also heard Mr. What is your name?
SM Munir on behalf of K. Mohammed.
SM Munir, who prays for an adjournment on the ground that his senior, who is the conducting counsel for respondent number 2, Mr. K. Mohammed, is on legs in a different court. The prayer is allowed. Let this matter be listed on 20th of March. 20 March.
Yes. I have filed the IA lordship for stay of the further proceeding lordship. Because in the main case, notice was issued lordship regarding the quashing of an complaint lordship, which is completely backstretched. As because lordship, the petitioner father is staying at Silchar alone. Prior to that, the complainant make some Twitter message for which she has filed. She was working there at Bangalore, and she sent a Twitter message to the Honorable Chief Minister.
Now, whether the respondent has appeared,
Lordship, he has appeared, Lordship.
he has appeared.
Lordship already appeared. Their name also shown, Lordship, in the cause list.
Where are they today?
Lordship, in the morning, I have talked with him, Lordship. I told him it because last 2 occasions it was not raised. And
Now what is to be done?
Lordship, I pray, Lordship, because
But
the
not on their back. If they have appeared, you inform them, let them appear. I'll consider your prayer.
Lordship. Because already last occasions also there in the morning also I asked him also Lordship. What happens, Lordship? The learned court will is not allowing any time, Lordship. I have no objection to Lordship. In my IA page number, kindly peruse that order, Lordship. The learned court below, we filed a petition there. Then the learned court below, page 17, Lordship, of the IA, kindly peruse, Lordship. At this stage, I pray, Lordship, the further proceeding of the
No, but not without hearing the other side.
Lordship, please. I understand, Lordship. Can it be on? Because
You suggested it.
Lordship, may I pray one thing, Lordship? Because since I have a IA application, could it be listed for again for orders, Lordship, so that to enable to reach it early, Lordship? Because nowadays maybe he left the court to the fasting days is on.
When you want.
This week, Lordship, subject to court.
Next week, Monday. Monday or Tuesday.
As your Lordship pleases.
Heard Mr. K. A. Majumdar, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. None has appeared for respondent number 1 on call. Let this matter be listed in orders column again on 18th of March 2025.
I will, it's subject to convenience, I will mention it in the morning so that to enable to get it listed. Otherwise, last 2 occasions also I waited, Lordship, for that. Actually, that matter for admission shows that it's nothing but a Lordship defamation case as well as civil case also filed by the opposite party. Their side.
Okay, we'll consider.
All right, Lordship, since they are not here, I will not. On 18th, Lordship.
March obliged.
May I please, Your Lord. My lord, here we have filed a quashing petition, my lord. What happened, my lord? We are the leading dealer of pharmaceutical items at the place of our stay with my lord at Pasarkandi, under Pasarkandi, my lord. And my lord, we have got a drug license. I take your lordship to annexure 1 as annexure 5 is page 33. Kindly, it is a GST in the name
Who is
of
appearing for the other side? Only additional public prosecutor. Yes.
But I have not gone through lordship the scan copy.
Let it come Monday. I have got permission.
You go through it.
Let him,
On Monday,
let my
Lord.
friend get
Okay.
the opportunity.
Heard Mr.
Monday.
S. C. Vishwas, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. The scanned copy of the trial court records have been received. However, learned additional public prosecutor has submitted that he has not gone through the same and seeks some time for going through the same before he makes his submissions in this case. The prayer is allowed. Let this case be listed again on 17 March 2020.
May it please, your lordship. My lord, a scan copy of case diary was called for, my lord. As per office note, it was not issued, my lord.
Heard Mr. T. K. Bhuya, learned counsel for the petitioner, also heard Mr. K. K. Das, learned additional public prosecutor. It appears from the office note dated 7/3/2025 that the scan copy of the PRC case, PR case number 1179/2022, which was called for in connection with this case, has not yet been received. Issue reminder for the same. Let this case be listed after 2 weeks.
Prior to 26, my lord, because next date is fixed on 26/3, my lord.
On 24th March.
Deeply obliged, my lord.
It is an option.
Lordship, senior counsel Mr. Deepananda is out of station, seeking an adjournment.
Who is out of station?
Senior counsel Mr. Deepananda.
Okay.
He was leading this case, your lordship.
Yes, Mr. Hamid.
Lordship, there's a stay order in this case. But that stay order will create some problem because we file a written objection to the petition also, Lordship. Because pursuant by this order, Lordship, there's a possibility of granting bail, Lordship. So
Oh.
if this order remains, Lordship, there may create problem because
We'll fix a short date when he will come.
Will come today itself. It may come after 2 weeks.
Not after 2 weeks. There is a stay order.
Stay order is
Next week it will come,
Next week, your lordship.
let it be on 17th, Lordship.
17. Heard Mr. What is your name?
Borpujari.
A. Borpujari, learned counsel for the petitioner, who submits that the senior conducting counsel, Mr. D. Das, is out of station, and on that ground he prays for an adjournment. On the other hand, Mr. M. Haloy, learned special public prosecutor, CBI, has submitted that a stay order is operating in this case, and there is an urgent need to hear this matter. What is the difficulty?
Difficulty because he was not granted bail, Lordship. If this 409,
Okay. I will not mention those things now. And prays for an early day, fixing an early date for hearing this criminal petition. The prayer is allowed. Let this matter be listed again on 17th of March 2020.
Thank you.
24. Report was called for Zimma Lordship, a commercial vehicle, truck Lordship.
Report has come.
report has not come, Lordship.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor, who prays for some more time for procuring the report which was called for from the investigating officer. Prayer is allowed. Let this case be listed on 18/3.
Diploma.
I think 50 from certificate is. My lord, in this case, my lord had called for a scan report.
My lord, I have just entered my appearance on behalf of the respondent number 2, my lord. So I pray for some time, my lord, to file an objection in this case, my lord.
Okay. Heard Mr. M. Kotoki, learned counsel for the petitioners. Also heard Mr. K. K. Das, learned additional public prosecutor, as well as Mr. R. Islam, who is appearing for respondent number 2. and who prays for some time for filing objection against the prayer of the petitioner in this case. The prayer is allowed. Let this, let this matter be listed after 2 weeks.
2 weeks.
Or
Well,
when-
in the meantime, well, the copy may be supplied to me. No. Copy to Paul. The by post.
Release this matter after 2 weeks.
My lord, can a date be fixed? Because
Suggested.
2 weeks.
we are getting.
Suggest.
Yes. So, to it, my lord, first of,
The 28th of,
May it be 29, my lord.
29th of March.
29 March, is, my lord,
Or
Saturday.
Saturday.
It is Saturday.
Well, the 1st of April?
1st of April.
Yes.
First of-
1st of April.
I'll find it in the.
Yes.
Made to the. My lord, in this matter, my lord, the limited point for consideration was whether, my lord, the court can convict a person only on the basis of 164 statement. Now, that is reflected in the earlier order, my lord.
Evidence in essence extra होगा. Evidence in essence extra.
Your lordship may kindly see the judgment, my lord, which I have annexed in my IA matter. Page number 19. IA matter, page number 19.
Yes.
My lord, the accused is convicted and sentenced to undergo rigorous imprisonment for 6 years with fine up to rupees 3,000. In default of fine, another period of 3 months under section 366 IPC. So for 366, my lord, he was sentenced to imprisonment for 6 years. Then, my lord, a rigorous imprisonment for 10 years with fine for rupees 4,000 in default of fine another period for 4 months under section 376. So for 376, my lord, the sentence was for 10 years, and for 342, the sentence was for 1 year, my lord. Now, my lord, the petitioner, my lord, he was taken into custody, my lord, even before pronouncement of the judgment. So, my lord, till date, my lord, he has probably, my lord, crossed 5 years in custody, my lord, in judicial custody, my lord. Now, the thing is that, my lord, regarding, my lord, 366, but I have nothing to say, my lord, because he was sentenced only to a period of 6 years, but out of 6 years, he has already completed 5 years, my lord. But regarding 376, my lord, if your lordship will kindly see, the
Regarding 366, you don't have any.
already, my lord, 5 years he has already completed, my lord, and even more, I do not know, because he was already behind bars, my lord,
Okay.
at the time of pronouncement of the judgment. If your lordship will kindly see, the evidence of the victim, that is at page number 15. Page number 15. Para number 12. May I repeat, madam?
Yes.
PW4X, that is the victim, has stated in her evidence that the informant Aklima Khatun is her mother. She lives at her grandfather's house. The accused gave proposal to marry her, but the same was not accepted by her parents. She was student of Lokhiganj Higher Secondary School. On the day of occurrence, she went to school. On her way to school, when she reached in front of school gate, the accused got her into a car, gave something to her nose and took away. She became unconscious. When she got sense, it was 4 p.m. and she started to cry. The accused took her to his house. He snatched away her mobile. The accused kept her for 4 days at her house. Her family members recovered her from there. She gave statement before the magistrate. Exhibit 2 is her statement. Exhibit 2(1) is her signature. Now, my lord, will kindly see the appreciation part, my lord, at page number 17. At page number 18, my lord.
Page number 18, the appreciation part regarding 376. The first line. May I read?
Yes.
PW4X has stated in her evidence that the accused kept her in his house for 4 days. In statement exhibit 2, that is the 164 statement given before the magistrate, X has stated that the accused had forcefully married her and kept with him. The defense has put no question to PW4X in this regard. So it can be easily perceived that the accused had voluptuous relation with X when he left her with him, and he did by force. The evidence of PW6, Dr. Rinku Ahmed, the medical and health officer who examined X, found no symptom of rape on X. So, my lord, regarding, my lord, the physical relationship part, my lord, that was totally missing in her 160, in her evidence, my lord, before the court. What, my lord, the court went back and relied on the statement which she has given before the magistrate to convict the accused, my lord, under section 376. On that point itself, my lord, lordship wanted to know if there was any judgment, my lord, on the law that whether 164 statement can be substantive evidence or not. But since 164 statement does not stand the test of cross-examination, my lord, so it cannot be termed as a substantial evidence, my lord. Regarding that, my lord, I have found the judgment also, my lord. Condition 376 is condition 366 is after 76 is the nice one. Para number 14, man.
Yes.
Evidence given in court under oath has great sanctity, which is why the same is called substantive evidence. Statements under section 161 CRPC can be used only for the purpose of contradiction, and statements under section 164 CRPC can be used for both corroboration and contradiction. In a case where the magistrate has to perform the duty of recording a statement under section 164 CRPC, he is under an obligation to elicit all information which the witness wishes to disclose. As a witness who may be an illiterate, rustic villagers may not be aware of the purpose of which he has been brought and what must disclose any statements under section 164 CRPC. Hence, the magistrate should ask the witness explanatory questions and obtain all possible information in relation of the said case. Then, my lord, will kindly see section para 16. Section 157 of the Evidence Act makes it clear that the statement recorded under section 164 CRPC can be relied upon for the purpose of corroborating statements made by witnesses in the committal court or even to contradict the same. As the defense had no opportunity to cross-examine the witnesses whose statements are recorded under section 164 CRPC, such statements cannot be treated as substantive evidence. So, my lord, regarding, my lord, the 376 part, my lord, there is nothing in her evidence before the court. So the court simply relied on her statements which were made prior to that matter for convicting the accused. That is my only submission, my lord. Lordship will see the record now.
Yes.
So I have gone through the LCL lordship here in 164 and the evidence of the victim lordship, PW4 perhaps, PW4, no? PW4. But lordship, I have not found in 164 also that she has implicated that this accused person regarding any rape, offense of rape lordship.
Have you gone through 164?
164 I have gone through lordship.
Okay.
That is fake money, it is fake money lordship. But there is nothing about committing rape lordship. And even one PW4 lordship, her evidence also she has not stated anything lordship.
Only statement is that she was forcefully taken up.
Forcefully taken up, that is regarding that will be 366 will come lordship.
366.
So regarding 376, I have not found any material from his statement lordship. In 164 also lordship.
Okay. Amita, part dictation. Mr. S. Das, London. Counsel for the appellant has submitted that the petitioner, that the appellant has already undergone has already served out the sentence, has already undergone imprisonment for more than 5 years, and therefore he has served out the sentence imposed on him by the trial court under section 360 He was sentenced under
366, 376 and 342.
served out the sentence imposed on him under section 366 IPC as well as under section 342 of the IPC. And therefore, he fairly submits that the appellant is assailing the impugned judgment mainly on the ground of erroneous conviction of the appellant under section 376 of the Indian Penal Code. Learned counsel for the appellant has submitted that the trial court had erred in coming to the conclusion of guilt of the appellant under section 376 of the Indian Penal Code merely on the basis that merely on the ground that in her statement recorded under section 164 of the Code of Criminal Procedure, she has stated that the appellant had forcefully married her and kept her with him. He submits that while deposing as PW4 before the trial court, the victim girl had not uttered anything which would implicate the appellant under section, which would implicate the appellant for offense under section 376 of the Indian Penal Code. Stop. Learned counsel for the appellant has submitted that the trial court had committed error in considering the statement recorded under section 164 of the CRPC as a substantive piece of evidence and relying on the same to come to the conclusion of guilt of the appellant under section 376 of the Indian Penal Code. To substantiate his submission, learned counsel for the appellant has cited a ruling of the Apex Court in the case of R. Shaji versus State of Kerala, wherein the Apex Court has observed as follows. Quote para 14 and 16 from this. R. Shaji versus State of Kerala reported in 2013 one crimes within bracket SC 217 SCC citation backline. Stop. The learned counsel for the appellant has therefore submitted that the conviction of the appellant under section 376 of the Indian Penal Code is not sustainable and same is required to be set aside, and the appellant may be acquitted of charge under section 376 of the Indian Penal Code. On the other hand, learned additional public prosecutor एक और line लिखना. Learned counsel for the appellant has also submitted that even in the medical report of the victim girl, there is no indication that she was subjected to forceful sexual intercourse.
May I leave? Yeah, court of appeal versus.
Yes, yes. On the other hand, Mr. P.S. Locker, learned counsel, learned additional public prosecutor, has also fairly submitted that the trial court trial court seems to have committed mistake by relying on the statement of the victim girl under section 1, recorded under section 164 of the CRPC, as in her said statement also she has theory of judgment on certiorari of judgment on 13th of March 2020.
Highly obliged.
It is a tied up matter
It's a tied up.
that is causing problem actually. Because today also you have only 20 minutes.
Right.
Will it be possible on your part?
To conclude, of course, no. Perhaps my friend begins, then can again carry on.
In any case, it is a tied up matter, so does not matter.
Then we have two options. First is to release it from Parthad. Second, we have to adjourn it for 2 weeks.
Then if we can pray for a listing as a top of the list matter. No?
Yes, because this is the flat matter.
Lord?
Flat, some
No, flat
doctor
matter,
doctor
flat
is
matter.
there.
That matter.
A doctor couple, I mean, that's how there are two appeals. You know?
My lord, the difficulty is that I will be there till 20th, 21st, my lord. Or thereafter, I will be before the other benches, my lord, outlying bench, my lord. And again, so the only, if your lordship has to hear this matter, then perhaps the only day.
20th.
No, 20th, 20th, yes, 20th would be there. 20th, lordship will be
Then we will release it.
My lord had heard it substantially.
Some
outlying bench.
or after 2 weeks because
This bench will not be available.
not be available for 2 weeks.
Right. Then, my lord, perhaps on 8th or 10th of April.
Yes, 10th of April is okay.
My lord.
Heard Mr. N. Burwal, learned counsel for the appellants. Also heard Mr. B. D. Dekar, learned counsel for the respondents. Due to paucity of time, this matter could not be taken up today. List this matter on 8th of. On that day, you may pray for upgrading it.
Upgradation.
8th of April.
Tenth.
Yes.
Will your lordship observe that in the order?
No, no.
We'll make a prayer.
No, no. Considering the circumstances on that day.
8th.
The same order.
Same. These are correct.
Same order.
Like.